Well, may kindly be taken up tomorrow. The urgency, my lord, is that the petitioner is suffering from various ailments, including a stroke, and his passport has been seized. That is why he is unable to leave the country for treatment. That is the urgency.
Interim bail, what ground? Ground. Mother serious.
My lord, 3 memos are given, not listed. 3 years, 8 months.
Have you given the memos?
3 memos are given.
Just see why not.
My lord, serial MC of the year 2021 for final disposal.
Item to mention, my lord, weekly list item number 62. Your lordship directed to list today, my lord.
Weekly list 62.
62. Matter has been settled.
It is there. Parties have come. What is the offense?
6 of POCSO Act, my lord.
What is the stage of the trial?
Convicted, my lord.
Convicted.
Convicted. I have given the Supreme Court judgments, my lord. Victim and the informant coming today.
After conviction, have you got some any judgment? Supreme Court that is under 142. That's that will not. In the appeal, can it be done or not?
The Supreme Court judgment is there, man.
What Supreme Court says? Supreme Court can do it. Whether in the appellate court, High Court can do it or not. That is the question.
There is a recent judgment also where the court cannot interfere in the conviction. They can reduce the sentence, but they cannot interfere in the.
So that is what I told you. Get some judgment. Supreme Court under Article 142 they can exercise. That
I will give, my lord.
Constitutionally.
I have judgments, my lord. I will give you. Kindly taken up after long, my lord.
You get some judgment. If you can pursue, then yes.
I know. Item 59. There the appellant has been convicted for 10 years. In 1 lakh for non-payment 2 years. Now he is in custody for 11 years, 9 months. And my lord, he has been granted interim bail for 3 months. 3 months is 6 months. But in the particular case also, my lord is on 31st.
So today is the supplementary release.
Weekly.
Weekly, yes.
So in the month, my lord, on 31st January 2022, my lord has also stayed that reliance on the fine amount. So it means
he should have been out.
My lord.
Yes.
But he is still in custody.
Shall I dispose it up?
Yes, my lord, because of the fact
undergone.
That yes, undergone.
Come at 2 o'clock, I'll dispose it up. Dispose it. And give me the period of custody, that's all.
1 of 2022. Okay. That custody certificate. That is there in the judgment itself, because from the date of my lord found from the judgment, from the date of his arrest, he is in custody. And after the particular judgment is pronounced, till date, it is under the.
No, in between any interim bail.
Yes, interim bail. Yes, interim bail.
So how much he has already?
3 months, 3 months. It has been posted. That is
okay, just give me a cheat.
Yes,
writing the dates when he went out and
before that. I'll
so that we'll calculate. Yes.
I'll come at 2 months.
Yes.
Any mention?
My lord.
From the list?
Item number 2. A specific instruction was to be taken from the learned court below. The same has not yet received. I pray for next week only.
Not received.
Next week only.
Report hasn't come.
We have to take instruction from the lawyer in the court below, my lord. The same has not been received. Pray for next week, my
lord. Last time also you took adjournment. How many adjournment?
No,
what is this matter?
Last occasion, your lordship, the matter was heard before your lordship, where the accused is the victim. The stage of the trial has to be ascertained from the learned court below. So I pray only for the next week, my lord.
Last time simply did judgment.
My lord. For the same reason, that instruction.
On the request of Hon'Ble the petitioner, release the matter on 27th. Yes.
Obligation.
Item 1 to 5, any mention? Item 6 to 13, 14 to 20, item 19,
19. Yes.
21 to 24.
Item 21. This case is raised for extension time and some modification. In the meantime, the accused person already released on bail. I pray before the trial court for some mistake there. 2026 or 2025 Vitropat.
No, the only bail, modification.
Yes, ma'am.
So the number is in place of 25, 26 should be it. Okay. Modification. Yes.
25 to 29.
1 minute. One minute. কি করছি অর্ডার কি করছি and yes
25 to 29, 30 to 32, 33 to 37, 38 to 42, 43 to 49, 50 to 53, 54 to 59, 60 to 66, 67 to 70, 71 to 79.
Well, item number 68, my lord, 1 week urgent.
My objection.
okay
But whole yes, this is legal because he has taken into.
yes it will be taken up today
Yes.
yes
Item 1,
The present petitioner has challenging the order passed in the complaint petition 115 of 2020 or order 12 4 2021. The magistrate has taken directed to the complainant to file necessary sanction from the accused authority under 197 as the this is a complaint is.
what are you seeking passing of the order 12/4/2021 where is that order yes what does it say 12/4 of today for cognizance of officers and counsel being a complaint case the accused persons the public servant obtain sanctions and for non complaint is directed to file necessary sanction from what is wrong in it.
Well, this is a complaint case. The police has committed forgery, the mischief. That is not under the discharge of duty, my lord. Therefore, the cognizance may be taken at time of the end of the trial, my lord. From the an initial stage, they are
You are for the complainant.
I am the complainant.
No, what is wrong? You get the sanction, apply for sanction.
But the case was dropped, my lord.
Where is it? It's not dropped. It only said that.
Only sitting the
Where is it? See the order.
the actually ending is 9.
Sorry?
The ending is 9 that is the concerned authority 197 of actually direction they charge.
Then you get it and then it cognizance will be taken. That's what he says.
I am the private.
Case is not drawn.
I am a private. I am the private individual, my lord. The complaint petition may be
It says that he is a public servant. You might have complained regarding his official duty.
Yes.
He might have done something in office. What is the complaint?
complaint petition is my lord unanswered.
Where is the complaint?
Unanswered 2, my lord.
2. Let us see. What have you complained? What is your name? You are Yogeshwar. Okay. You have filed the complaint. So case is
During
police.
the case 16, my lord, during investigation of the noted case, investigation officer visited the spot, examined the complaint, and seized the ROR Thata number, measuring number, stand record in the Pitambara Pandey. That is something.
Police station fire was issued from to.
The present investigation officer is the present accused who never seized any document from my client or to Jima to complain any document in connection with case.
Complaint mentions that you not accused. So therefore, you are complaining regarding his conduct while doing official duty. That's why sanction is required. What is wrong in it? Show me any law.
As per the official discharge, say any court has obtained sanction from the authority.
Why? It is your complaint. You have to apply for sanction. Have you applied for sanction?
I have no instruction.
Then you have to apply for sanction.
Next week, I have an instruction about
You have to apply to the superior officer. Say, this is the complaint I filed. These are the allegations. And please grant sanction.
or the status of the court below. I have no knowledge about the status of the court below. Then next week,
The complaint you filed when?
2021.
2020.
20 yes, ma'am.
Unnecessary, you are delaying it. There is no nothing.
This is a transfer.
There is no illegality in that order.
This is a transfer. This is the first time I am going to do this.
But that is a different story. But there is no illegality.
Only next week matters. Only next week, only obstruction the case is pending or not. If pending, I have.
This petition is pending since 2022. Since then, the petitioner has been seeking adjournment in this one. Twice the matter was listed in the year 2023. Thereafter, for the first time, the matter is listed today. Letter counsel appearing for the petitioner is again seeking for time in the interest of justice. Last opportunity granted, list the matter on 19th.
Yes.
19th. It is made clear that no further adjournment is on any ground can be granted to the petitioner. Yes.
Item 3. My lord, please. My lord, interim there. My lord, JCRLA 167/24 and IA 198/26 for interim bail.
On
My lord,
entry bill on what grounds?
Ground, my lord, his mother seriously ill, my
Okay.
lord.
Yeah. Notice was issued?
My lord?
Notice was issued?
Yes, my lord.
The file, no, right. This is an application 119. It's an application seeking interim bail. The appellant has contended that his mother, your mother is terminally ill. In support of the same contention, he has filed certain medical document. Let the state council verify the same through the IIC and file a report by next date of hearing. Release the matter on 24th. Yes. 24th. Yes, next.
Item 4. This is the case.
Yes.
Pardon me, my lord. Interim to
Interim? I'm seeking, I'm getting a report.
Oh my.
Let us see here. Yes.
This is the case.
Mm.
Where I am being unnecessarily harassed by this malicious prosecutor. Follows what has happened in this case. Initially, the lands belonged to 7 Hills. Now, 7 Hills sold off these lands by way of plotting.
I don't think I can do this matter. I appealed against this petitioner in Supreme Court. This matter before some other matter.
Publish.
I think he was discharged in some case. And I challenge the discharge.
Similar, the directors who were actually in a controlling position, they have been already been exonerated by this honorable court, my lord, which order remains final and binding between the parties. Now,
That was challenged before Supreme Court.
no, that was not challenged. In his case, when this honorable court quashed the proceedings, that was challenged before the Supreme Court.
That I
And the Supreme Court said, this is not the stage, cognizance is not the stage, you can raise all your points at the time of discharge.
thereafter you.
Thereafter, we filed our application for discharge.
Do you have that Supreme Court
Yes.
order?
Part of the petition.
Final order. Where is that?
No, wait.
Page 166.
Yes. Yes. This SLP was filed by me.
Well,
Wait.
And this,
once
it was disposed of subsequently. Filed by.
okay.
Yes. Yes.
Item 6. Item 5.
Five, huh? Okay. Okay. Pokso is there. Huh? Pokso is not there. What are the options? Admit. Call for the High Court record and notice on the application also. Notice on the application for bail. Release the bail application after the PCR is received. Yes. Next.
Item 6. May I please your lordship answer? Reception matter and conviction for highest punishment is 3 years, my lords. And offense and during trial period, appellant was on bail, my lords, and subsequently after pronouncement of judgment, appellant filed the bail application before the trial court, and he was returned interim bail for a period of 1 month.
What are the offenses?
Offense, my lord, offense 3 years, my lord, conviction.
Also is there.
मासे हमको condition bail मिली थी, I have filed
I have
the
to issue notice and reach it immediately.
regular is the bail application, my lords.
That's what I'm saying.
My lords.
Admit. Admit. Call for PCR on the application issue notice. Notice to be served through the IIC. Notice to the victim and public informant to be served through IIC. Reach the matter on 21st. 21st, yes. Yes.
Item 7, bail, man,
For bail only I have to issue notice. Yes.
to regularize the bail application.
Yes, yes. That's why. Yes. Sir.
During trial, after pronouncement judgment, my lord, appellant shall.
Sir, I can't pass an order without issuing notice because it is a POXO case. So I have issued notice. I gave a date, 21st is the date. Yes.
Item 7,
Denied to the law. Conviction for 10 years and fine of rupees 20,000 for section 4 of the first case, my lord.
Okay. Admit. Call for the court. The bail application. And a stay realization of fine. Stay realization of fine. Bail application. No, issue notice to the informant of the victim. Release the application of the basis. Yes.
item 8,
My lord, I am appearing through VC.
Yes.
On last occasion, the opposite party has taken time to collect the briefs from government, and for which this is adjourned. The case is that the appellant is a civil engineering consultant and is engaged in project facilitation in which the agreement has been made with POSCO India Limited to purchase the land and to transfer the same to government of Orissa. Accordingly, the land has been transferred.
What are you challenging?
I am challenging the order of the appellate tribunal,
Yes.
New Delhi, under Benami Act.
Safema.
My lord, obliged.
Yes.
That is the case. My lord, is that
That is not where are the other documents? Nothing is there.
My lord, I have made an appeal. The other documents is to be LCR is to be brought from the.
Why this is you have to file substantiate its case also.
My lord.
Yes, what do you say, Mr. Agarwal?
Your Lordship, in this case,
Yes, sir.
it's a Benami transaction has been done as per our. He has only filed an appellate order only. He should have
That's
filed
right. What he says is call for the record. Let us call for
adjudication order, or he should file that adjudication order.
There is nothing. Adjudication order. Minimum thing you should file.
My lord.
Order must be there with you.
My lord, it is also.
Now.
Everything is also with me because the same is
Then-
asked for by this honorable court in previous cases, for which I decided
I'll
not to.
simply
make
issue
public.
notice without admitting. Yes. Issue notice, Mr. Kedia, Avinash Kedia, accept notice. Call for the record from the Safema Tribunal, New Delhi, pertaining to FPA/BP-PT-1861 public BBC at the top with you. File pertaining to and list the appeal for argument on admission after the records are received from the tribunal. Yes. Yes. Next.
item 9,
9 is also similar matter.
Similar. If
9 is similar.
yes, 10.
Same case.
item 10, please lordship. The appellant is convicted under section 65(2) of BNS read with 6 of POXO Act and sentencing to undergo rigorous imprisonment for 20 years and pay a fine of rupees 15,000.
Admit realization for final stage is a notice on the application for yes. Yes. Next.
Item 11.
It is also POCSO and
Abstain.
stay up relation fine.
Stay realization. Yes. 12.
Item 12.
Same also.
POCSO.
So, 10 minor.
Same.
Conviction 5 years. Stay for
Yes. Yes. 13.
Item 13.
Same.
Same also. Same also. POCSO. Yes.
Item 14.
Sentence for 20 years matter. Offense under 376 3 matter. Notice
Then notice. Admitted of yes.
stay.
Stay realization.
15.
15 through virtual my lord.
Yes.
Simple imprisonment for 2 years on each count, 13(1)(c) and 409.
Bit for
And
record.
he has mentioned that he was all along on bail.
Yes, the admit also the appellant was on bail during the entire trial period. This is the order after conviction. The sentencing court by order dated 29/6/2026 extended the benefit of Section 389, Bracket 3 of CRPC, and suspended the sentence for the how much?
Page running page
2 years. No.
55. Running page 55.
Suspended sentence. Till the
SI for 2 years.
still the DPG is preferred to the application. The application, the bail application is allowed. The for the reinstating the application, the sentence stands suspended pending appeal. Accordingly, the appellant is released on bail on so forth. Yes.
Fine may be still.
Fine is fine state. Yes.
16.
And my appearance may kindly be named.
Yes.
Okay.
Yes,
May I
madam.
please allow?
8 POCSO,
76 BNS.
3 years in both.
There is a prisoner's petition also.
Yes, yes.
Prisoner's petition, huh? The petition, as per received the appeal along with the from the jail, along with the prisoner's petition, as per the prisoner's petition, the convict appellant as requested to appoint just to call advocates to conduct case. Have you filed the wakalatnama?
Yes, Your Lordship. Today morning I filed
Yes,
it.
already filed the wakalatnama. Appeal admitted and the realization of fine paid, and in so far as the bail is concerned, issue notice to the informant, public the victim to reach out to the IIC.
Lordship, there is a delay of 48 days that may
Delay control.
oblige.
Yes.
17.
May I please, Your Lordship? In the last occasion, Your Lordship is directed to State Council to obtain instruction whether the district consumer forum policy is totally paralyzed or
Yes, man. For last 7 years after the in absence of president, forum is not functioning.
Sorry?
Last 7 years in absence of president, forum is not functioning.
Oh.
They don't.
Then it has to entertain. This writ petition has to entertain.
Your Lordship, that
Issue notice. Only pursuant to the order dated 5/8/2026. The state council is also informs that the district consumer forum, Baleswar, is not functioning. As the presiding officer. In view of the same, the writ petition is maintainable. In view of the same, the prayer made in the writ petition is liable to be liability entertainable. Accordingly, issue notice to the respondent written rule from. Okay.
But till then, no corrective action should be maintained.
What is the order?
IA.
Financial.
What is the district forum?
Default in payment of
Let us show me the let us see.
Finance from Bajaj Mahindra and Mahindra Finance OP number.
No, show me the order of district forum which you are challenging.
The order is not there. I have filed consumer case which is pending before the Balasore District Consumer Forum. And I have filed the IF not to take any correspondence.
No, you filed that is not entertained or what? Let us see that order. Let us see. Where is that? 17, na? Item 17. Yes. What are you seeking? So I'll allow this petition. If it is not functional, he is seeking only transfer. Transfer from
Consumer Forum to near neighbor district, either Bhadrak or Marivan.
Baleswar to Bhadrak.
Bhadrak.
Which is near?
District.
Bhadrak.
Bhadrak and transfer. Right on. The petitioner invoking the jurisdiction of this court has sought for the following early. When the matter was taken up on 5/8/2026, this court directed the State Council to verify, obtain instruction regarding the reason for the non-functional of the District Consumer Forum at Baleswar. And for the state, obtain instruction and submits that why it is not functional according to you?
Absence of precedent for last 7 months.
Last 7 years.
7 months, not 7 years.
Submits that
3 years appointment was there.
Submits that since the president of the forum has not been appointed as yet, the consumer forum is not functional since last about 7 months. 7 months.
Not explicitly.
In view of the same, the prayer made by the petitioner for seeking transfer of the consumer dispute case, consumer dispute complaint complaint to the neighboring district, teachers merit to be considered. In view of the same, the writ petition is allowed. The consumer complaint case number 5 of 2026 filed before District Consumer Commission at Baleswar stands for to District Consumer Redressal Commission at Bhadrak. The interim prayer made by counsel for the petitioner cannot be entertained at this stage, but it is kept open for the petitioner to urge his interim prayer before the District Consumer Forum, Bhadrak. Once the consumer complaint is transferred for the District. Yes.
Till then, not corrective action.
No, you go there. I will not first.
I
have transferred it. I allowed it. Yes.
Urgent copy.
Yes.
Item 18.
In that annexure 7 is challenge our district commission. The appeal is there, appeal forum is there. And you got the liberty to approach the appellate authority.
The petitioner at the outset.
The limitation be condemned.
He may be given liberty to resort to the right remedy under law against the impugned judgment or order.
Judgment and order.
Dated 21/8/2025, passed by and the
DCDRC
Consumer Redressal Commission at Bhawanipad. The writ petition is disposed of with the liberty at
That limitation period be condemned.
Oh, you will get section 14 benefit.
The 41 provides that
14 benefit you will get. Section 14 benefit you will get. Because you have
other legal. One sympathy.
What sympathy? 14 benefit you will get.
That is there.
Then If
That
liberty have been granted,
that certified copy be returned back.
certificate copy
Substituted the
in order filed with the petition be returned by the registry to the petitioner by replacing a photocopy of the section. Yes.
Will also may say that section 14 because they are not considered.
Section 14, shall I tell all the provisions? This is obvious. Yes. Yes, next.
Item 20.
19 that out of court settlement that has been
19. With 19 has been withdrawn. 19 has been withdrawn. 20.
Item 20.
Just file a miscase. Today it has been listed for vacation of interim order, that copy has not been solved. So here I have challenged the order passed by the district forum exceeding the jurisdiction because the limit is 1 crore rupees. And he has directed 1 crore 20 lakhs. First one. Second thing, in writ appeal, this honorable court granted status quo to be maintained in respect of the line in question. Now, the district forum has clarified in page 16.
What are you challenging here, basically?
Challenging the order passed by the district forum. We have also filed.
Why don't you go to state forum?
Because
Is all this point?
Because
why read?
We have filed a review, my lord. Review was also rejected.
Everything. You can check that in.
Though he has power, but now, my lord, to approach the district forum, we have to deposit, my lord, 50%.
That is you can move an application for waiver and whatever. Merely because you have to deposit doesn't mean that you will come to.
No, because it is without jurisdiction, palpably wrong, my lord.
Oh, that point also you can take it.
Yes, I can take, but here let's see, status quo order, the court has directed. The status quo means, my lord, the nature and character of the land should not be changed, my lord. Now he has directed to execute the sale deed in favor of appeal number 5.
You can ask for stay. What is the big deal about it? Your only apprehension is you came to writ court.
Yes.
Because the pre-deposit condition is hurting you. Only pre-deposit condition.
Pre-deposit is one thing, and second, it is without jurisdiction.
Without jurisdiction, that point can be taken away. You can take that point. If it without jurisdiction, state commission will.
That deposit your lordship may clarify so that. We are your lordship knows the status of. Your lordship knows the status of OSFC, my lord.
My lord, he is not entitled to get any equity. My lord, he has committed fraud upon me, my lord, since 2005.
I don't want to get into all these things because see, if the writ petitions are entertained like this, then the tribunals are redundant.
No, because we are, this is an organization, my lord. Not that individuals that committed a wrong here. It's an organization after 15 years, after 15 years of purchase. After 15 years of purchase, my lord, he has requested the OSFC to execute the sale deed. Thereafter, we have moved before the settlement authority, and thereafter writ application, thereafter writ appeal.
See, being the state financial corporation,
yes, sir.
You should not have any problem in even pre-deposit. Pre-deposit also you may not have problem. It is not an individual case. It is
problem because of the condition of the present condition of the
corporation. It is being created by your own officers.
Yes.
You know how.
Yes.
Yes. Organization.
That I know.
They spoiled the entire institution.
Yes.
I was appearing for this corporation for some time. Long way.
I have told them.
Completely mismanaged.
Yes.
Completely mismanaged.
Auction
I don't want to get into all that.
That is what my lord is saying is correct, 100% correct, because
I will keep everything open and you may move appropriate application for stay as well as for waiver also. That
for
also
release of pre-deposit.
Yes. No.
Release of pre-deposit.
I will not say anything. Whether pre-deposit is waived, then where is the question of release? Then petitioner State Financial Corporation has preferred this writ petition entry alias seeking following relief. Mr. and senior counsel appearing for the petitioner at the outset, and after arguing for some time, the minister he will be permitted to approach the state consumer forum against the injunctive order. He further submits that he further submits that the petitioner may be allowed to move the appropriate application for seeking waiver of prerequisites and also may move for taking stay of the operation of the imperial. Needless to say that it is open for the petitioner to move such applications along with the appeal. Along with the appeal, it is expected that the state consumer forums shall deal with the appeal as well as the application to be filed by the petitioner in accordance with the law. This court expressed no opinion regarding the merits of the case. In this observation, the writ petition is disposed of. Yes.
Till then, no, my lord, this application will be considered in accordance with law without being influenced by the any order.
Influenced by which order? Which order you tell me without being influenced by what? I have not expressed any opinion.
Till then, my lord, this order.
Which one?
Till then, 12-3 order.
12-3, where is that order? 12-3. 17-3. It's 12-3.
17 or 12-3?
Mediation it was referred. 12-3.
Yes, right hand. Right hand side.
12.
Date of filing, date of hearing, and date of judgment. Annexure 1, page 12.
No, till then, what do you want?
This order shall be.
Which order? Which order you are talking about?
12-3 order. One.
12-3.
Yes.
12-3. Where is that 12-3? You want say of that?
Yes, my lord.
I am not entertaining the review. I thought some interim order has already been passed by.
Yes, my lord. Yes, my lord.
This court has passed in the interim order?
Yes, my lord.
Which order? Show me.
21-6.
21?
21-4.
Where is that order? Let us see. Which part of the order?
Para 3.
Para 3. Instead of filing, sailing your
IN.
Where is the stay order? Where is the order?
Execution.
Interim measure.
Yes.
Stay of the further proceeding in execution case.
Yes.
Execution case. Okay. 1 minute. If I'm giving liberty to file appeal, how can you execute? The main order goes. Since Mr. Das has sought liberty from this court to file appeal against the impugn orders, the execution proceeding initiated by the respondent, being execution CC case number 1/4/2025, shall remain stayed till the appeal is prepared and the appropriate order in the interim applications filed by to be filed by the petitioner is heard by the state consumer forum.
Your lordship granting stay till filing of the appeal.
Till filing of the appeal, and he will say if it's not there, then it will
And
be.
that appeal may be filed within a stipulated period. That may be otherwise they will
yes,
file
yes.
it after 2 months or 3 months.
No.
Since
And that is their conduct since 2005 only.
Mr. Das, how much? 15 days? Mr. Das further submit that within 15 days.
4 weeks time.
Maximum within 1 month.
Yes.
The
Maximum.
petitioner shall file the appeal. If the appeal is not filed within 1 month, the stay of execution proceeding which has been passed today shall be automatically vacated.
And the stay application, if he is filed in the appeal, that may be independently decided without being influenced by the order of this honorable court. In so far as this transaction application.
Needless to say that the interim application to be decided by the state consumer forum shall be without influence by getting influenced by any observation made by this court. Yes. Object copy. Yes.
22.
Notice has stated to have returned.
22 item, my lord. File is misplaced, my lord.
You are appearing for?
My lord.
You are appearing for whom?
Petitioner, my lord.
Huh?
My lords, with due apology, my lords, here initially Miss Patnaik had appeared. Since she had become a state council, then we have appeared subsequent to no objection. My learned friend has nothing to do with regard to the present matter. I appear for the petition.
Yeah, no objection has been taken and he is
That
appearing.
is also right.
It's all right. Yes. What is this matter?
The notice has returned unserved. This is regarding dismissal of my protest petition.
Why are you not taking steps?
Lords, I have taken steps. If your lordship will see, the present noting is that
2012 matter. Is anything survives?
Lords, therefore I am only praying your lordship may grant me some time and coordinate because it has come up very suddenly.
See, 2012 matter, your protest petition is rejected now. See,
Lordship may grant me only a week's time.
what are the offenses, by the way? Let us.
Lords, in the complaint it was stated that the accused person had taken out of the fund of the Mart Millers.
I don't think anything survives.
Your lordship may grant me some time. I'll take instruction if they are willing to pursue.
Today is 17th.
Grateful.
17th. Yes.
23.
You get instruction, nothing survives. I don't think. Yes.
Petitioner is a practitioner of this court mail. The lordship pleased to issue the notice to the informant, but he has not appeared. The informant is a police personnel matter. And the allegation that the very day there was
Service
a
is already there.
in that area.
Service is sufficient.
Service sufficient. And
What are you seeking?
the questioning of the proceedings. He was not at all present at that time, madam. And the witness which he has cited, and he is a person who has the
Cognizance order you are challenging.
Yes, madam.
Yes.
And the informant is a ASI who was posted only 15 days back. How could able to know my name and other things? And it is a totally very manifestly they have lost the affair and also
So the cognizance is taken for the offenses
very small
341, 341, 186, 431, 34 IPC. And it is against as many as 8 people.
Yes, madam.
Then how your case is different from others?
Well, my name, father name was not there. And I have been the witnesses which has been cited.
Just see, if you see Annexure 1, your father, you are Sanjay Kumar, accused number 2.
Yes,
your father name is late Udainath Das.
In the affair, the name was not there. My father name is late Anil Das.
Oh, all these things can it be gone into the?
I have no nexus with that incident. I am a lawyer, and only as I
you are a lawyer doesn't mean that you have immunity.
I have a member of that puja committee, for which
what are the allegations? What are the allegations?
The allegation there was a waterlogging in that area, for which at that time there was a protest.
How will I know that you are not there? Merely because you are saying.
The witness which has been cited, they was not at all present in that area.
Oh, can I go into all these things?
Witness has come forward, the lordship, before the lordship. And he says that at that time I am serving as an army personnel in the outside of the state. And only that Delhi
army personnel, you said you are a lawyer?
I am a lawyer. The witness who was implicated in me as per the IO, my lord, and as per the informant, he doesn't know anybody. He only 10 days back he was ASI in that area, my lord. How could able to know my name and my father's name?
I don't know. These things cannot be, the probative value of a statement made in a 161 state by a witness can be tested at this stage, at the cognizance stage. Tell me.
He has only the cited one witness, Dilip Singh.
That's what I'm asking. You answer this question.
Present at that time, he was working in the outside.
How will I know?
And he was also.
You have to, when in the cross examination, you have to put it.
Yeah,
you are not present or something.
Already affidavit he was filed by that witness, man.
He was not present.
No.
Where is that affidavit?
It was
only one witness.
Dilip Singh.
Show me the charge sheet. Show me the charge sheet.
And other witnesses also not named.
It's a very. Just see, Mr. Das, which
Yes, Your
witness have said.
So that's chat sheet. That's it.
Case 32, my lord. Dilip Singh. He has
Para
stated-
18, when it is written a brief fact, the name of Rana Surya Das Gupta is there, and the FIR also name is there. And the what is the
Surya Gupta,
Yes, Surya Das Gupta,
the petitioner's name.
petitioner's name.
He is the ASI who has joined only 10 days back, my lord.
You come to the first statement. The first statement, that is Sri
Pranab Kishore Praharaj.
Pranab Kishore Praharaj.
Yes, ma'am.
He has also taken your name. Just see, Surya Das Gupta. How do you say that only one witness have taken the name and you obtain an affidavit from him?
He stated, my lord, Surya Das Gupta, Dilip Singh.
Although he was taking he took the name.
My lord, what I am
And the second witness, Shalendra Sahu also taken your name.
My lord, the Dilip Singh, he has been cited as a witness. Who has
Asutosh Das is also saying.
All the witnesses have taken your name.
But he is saying that all these persons are present. And they
You
have cited as
answer one question. Can I see the probative value of these evidences which has been recorded by the police in 161 statement at the cognizant stage? I'll see and I'll start appreciating and pass a judgment.
That
Equitable.
But the allegation that can see. The allegation there, they have
Whatever maybe cognizance is taken. How will I?
That offense is not attracted, money. 186, 431 is not attracted.
Then what you know? Then what you have to do? Go and argue on charge. This offense is not made out. That offense is not made out. You have to tell me legally how can I do it. Merely because you are a lawyer doesn't mean that I will exercise 482. And if you would have been one accused, I can understand. 8 accused are there. If I will interfere in your case, all other cases has to be quashed. Why you will be treated separately? Merely because you are a lawyer. You may be a lawyer, but there are 8 accused. Why should I treat the other 8 accused differently?
The offense is 186, 431. What is the allegation, man? Waterlogging in that area, whether this offense is attracted, man.
Argue on charge. That's the best relief. Adjournment. What to do? Simply adjourn.
Actually, the petitioner trade of our trade my lord, High Court of Orissa petitioner my lord. On the particular date, my lord.
I'll simply adjourn. I can't help you.
The court of the way, the local persons may not gather there.
It's all right. See, there are
Only
8
standing there.
There are 8 accused. All the witnesses have taken the name, your name, along with the other 8 accused. If I'll give indulgence merely because you are a lawyer, what about the other?
Even if he has no knowledge, absolutely. When someone issued to him, he came to
You may be correct, but see, legally, how will I, quash the cognizance order?
The informant କହିବେ ଯେ ଆସିବେ କମିଟେବଲ ସେମାନେ
You bring the informant, despite service, the informant, opposite party number 2 has not entered appearance in the interest of justice. You bring him, I will quash. As simple as that.
Informant is the ASI.
If he'll bring he is a lawyer, he can bring, so that other 8 people will also be escaped.
Only one.
You bring him here, I will quash it. You tell me the date. If tomorrow I'm ready to take up. Tomorrow, day after, any time. You persuade him and bring him on 17th, Monday. Then you tell me next week anytime. On 24th. 1 week. So therefore, it's more of a reason you can bring him. Go and bring him, I'll quash it. And if you can persuade him to bring him tomorrow, day after, anytime you tell me, mention it, I'll take it up and quash it. Okay. 24th, I'm keeping it. See, that don't do it, I'll tell you. Then it will go on and on. I'm ready to quash it. Why are you unnecessary? Bring him. Yes. 24.
He can. The person has come in my name. I mean the winner tomorrow, today, my lord. That will be taken up next week, my lord.
Next week. Yes. 25.
25. May I please, Your Lordship, in
Yes.
this matter, the petitioner has been granted bail twice. The first occasion, that is on
10 years.
2/4/24, 2nd April 20, and the second time was on 13/9/24.
You are seeking bail now, regular bail.
Yes.
Okay, call for the report. The report, custody certificate, antecedent, and the jail conduct. Yes.
Your Lordship, conduct certificate.
Next.
26.
Last week of September and first week of October.
My lord, pass
Yes.
over.
20?
26, my lord, pass over. My lord.
Pass over. Okay.
27.
27.
27.
Because he has been convicted under 307. And this honorable court, by the last order, his bail was rejected by this honorable court at the initial stage. The order
Call
was
for a
that
custody certificate and all.
after 5. Your
Yes,
Lordship have
have you
asked
got
for
it?
the custody certificate and his conduct certificate.
Yes. Let us.
After 5 years of imprisonment, my lords to renew his bail, and 5 years have already gone by. That's why
Total sentence is
10 years. 5 years is already
2 criminal antecedents.
1.
Has been acquitted.
And he has been acquitted in that case. And this is the other case.
On case charges.
You undergone about 5 years, 5 months.
Yes.
23 days. Is on date. And you have one criminal antecedent.
Has been acquitted.
And in that he has been acquitted.
Where is that? How can I?
29/4. I filed the document. I have the copy when I filed.
You file a comprehensive affidavit, right? Pursuant to the order dated 29/7/2026, the State Council has placed on record the custody certificate, which indicates that the convict appellant has already undergone for 5 years, 5 months, 23 days, as on 10/8/2026.
We filed
The
right.
IIC Palli Huda PS has also filed a report dated 3/8/2026, disclosing that the convict appellant is also involved in another case besides the present case. Learned counsel for the Mr. Sango, counsel appearing for the convict appellant submits that insofar as the other case is concerned, the appellant has already been acquitted in that case. Let a comprehensive affidavit be filed.
I'll give it at 2 o'clock. He is getting.
No, I'll release it next week. Next week. Keep it next week, 21st. 21st.
Okay.
21st, but please take it on the.
28.
Appeal where my lord. Custody in 17/5.
28.
17/5/2018, my lord.
Yes.
But, the glass on the
Sorry?
custody in 17/5/2018.
Okay.
I have a glass on the PWC.
Sentence?
Sentence, my lord, 20 years, my lord.
20 years. Call for the report. All three reports. Please. I'm calling for a custody certificate. Yes. Yes.
Single
Next.
antecedent or?
Yes.
29.
29. Yes, madam. Prisoner?
Resma Beraj.
A prisoner's petition dated 6/2025. The convict appellant is requested to change his lawyer, and appoint Nandini Shathpati. You have filed Vakalatnama? Pursuant thereto, Vakalatnama has been filed by Mrs. Nandini Shathpati. Yes. Yes. What do you say?
Yeah. The section 317 for
Call-
20 years back.
Yes. Yes, next. Item 30.
The appellant has been convicted for the
My power is just maybe deleted matter. Original person had.
Prisoner petition? No. Your power is you now prisoner petition has been filed. Where is the prisoner petition? It has been allowed. Pursuant to the prisoner petition dated 18/8/2025, Mr. already filed and so name to be dropped from the college. Okay. Yes. Okay, have you got the report? And
No, Your Lordship.
earlier there was a direction already. And what about the notice?
Notice is sufficient, Your Lord.
Sufficient?
Yes, Your Lordship. 30. 30 to
Sufficient.
order dated 15/2/24 kindly see.
Yes, notice sufficient.
Yes, sir.
But nobody has entered appearance.
Yes, sir.
The person to the order dated 15/2/2024. Notice on the informant of the victim has already been served, but none has entered appearance on her behalf. Hence, I need the photo of Mr. Mishra or Mr. Mishra or the village of court. Least Mr. Dividi how she that lady was just speak for new people can get it. Yes. Further matter, yes. Mr. I appointed a Jamakishpuri to assist the report, and no report has come.
No, only the criminal antecedent part is there. No criminal antecedent, no adverse. But the period on gun is not.
Custody certificate and jail conduct. Call for jail conduct. Okay. And custody for jail conduct. Custody certificate and jail conduct and all. Yes. Next. 31.
Lordship petitioner filed IA for interim bail. Last occasion notice was sought and notice was sufficient.
Comment. Despite service, none appeared for informant as one more opportunity granted. State counsel serve the notice. Have you served?
Yes.
Interim bail.
Yes, Lordship.
What ground?
Petitioner's brother's forgery.
Document again. Delhi sir, I would copy again. Also.
I am talking about service.
So Your Lordship, service is already sufficient, Your Lordship. 10/9/24.
Service already effected, huh?
Already, sir.
10/9/24. Nobody appears now, despite service of notice on the informant of the victim, none appeared for help. Hence, appoint Mr. Of course. Also, appointed and you have to intimate.
Yes.
Intimate. And what about the report in the interim bail application? Interim bail application 1609. Not obtained.
Not obtained.
The state Mr. Das is seeking 1 week time to obtain the instructions regarding the. Have you filed any documents?
IA also.
No document. Yes. Regarding the health condition of the brother of the petitioner, and to verify the medical document and the application. Mr. Das has also filed the custody certificate with the contact and implement of the appellant, which is taken instance on 1st of September. In the meantime, the doctor will go the file protocol, the supply to the amicus curiae. Yes.
32. Reversible to take instruction.
Yes. Interim bail application. Yes.
Then Sabai item I am there for appellant.
Is in first matter? Nobody there.
Yes, but I filed an application for bail.
First matter?
Yes, ma'am.
Yes. The sub item, what are you seeking? Bail.
Yes.
Sub item bail, huh? What is the offense?
My lord, 22B2C. 20B2C.
Okay.
Conviction is 10 years.
10 years.
I am about 4 years in custody.
I'm calling for the custody certificate and your jail conduct as well as the antecedents. Then I'll see both the cases and release it immediately after the hearing. Yes.
And also my case also, man.
Yes. Yes.
33.
Yes.
9.
Convicted under section 376(1).
Yes.
Arrived for 10 years. Is in custody since 30th June 2020, more than 6 years.
Call for the custody certificate and your antecedents. All the cases.
Thinking that the report has come.
A report.
Because it was admitted since 16/7.
Report is there.
No, I think so.
There is no report. It is never called for. Never called for. Call for the report. Meantime, notice reserved yes.
34.
3rd September. Yes. 3rd September, I mean.
3rd September.
They will get it 2 weeks only.
More than can see para 12 of the judgment. Everything is very clear. There's no case at all.
At least they'll take 2 weeks. Can you get it before that?
At least 2 weeks after darkar podiyo.
So therefore 3rd is yes.
34.
7 years here. Out of 10 years, 7 years.
Yes, season half.
Then I will have to give little early. Let it be on 25th. 25th.
The 25th, 24th, 25th Mangalwar podiyo.
See, this is 24, appeal of 24.
Sir, 24 ko Tuesday podiyo na,
24, okay. 2024 appeal. 7 years undergone, what will you do?
Patterns actually para 12 se सब कुछ चाहे एक्सपेक्ट कर दे केमिति टाइनेशन
24 is good. Huh? Yes.
34.
So, 10 years conviction, but after the matrimonial relationship, one child is born, marriage is valid marriage is there. So, Lordship, before your Lordship, I have presented informant, victim, appellant himself.
What is the sentence?
Sentence by 10 years.
10 years. Undergone period?
Undergone 2 years फिलहाल.
2 years. Oh, notice has been served.
Notice.
Why you have called so many people for bail?
No, my lord. Previous date थीला, Monday थीला. So I was mentioning that after the
valid marriage, one minor child is born. So the
Now you show me any judgment after conviction, I can, in appeal, I can set aside the conviction on the ground of settlement.
the Mahesh Mukunda Patel as well as Lordship short term. I just did direct class.
Yes. Oh, Supreme Court can do it, 142.
142.
My
In
lordship,
appeal, can it be done or not? That's the question.
my lordship on recent judgment,
Ah.
just searched my lordship of Supreme Court. It
Yes.
said that it cannot be done, my lordship.
Then
In the paragraph also I have
that
already
is the
marked.
whole difficulty. I can grant bail only.
Yes.
So he's on bail.
He is already on bail.
In the paragraph I have marked.
Which
my-
paragraph, madam?
I have marked my lordship, paragraph 7, my lordship, kindly have a glance.
7, huh?
Yes. Para 7.
Yes. Yes.
Para 7 is the,
Evidence of the victim reveals that she also claimed that they married the accused. She stated that
the order is para, and the
she stated
para 42 is the order.
the house will and married the accused. She stated that since 2019 she has been residing in the house of the. Yes.
And para 42 is the,
Para
para 42.
42.
The court has set aside the order of the Hon'Ble High Court.
To that the accused is guilty of the offense. Issue regarding the sentence of the should have been
And impose the condition to the state to state for condition impose condition to
in this court, in this case, the trial court convicted.
Yes.
And
the High Court has set aside the judgment, though they have married.
Oh,
That's why my lordship it's put a kind.
same situation.
But I know appeal also I hear the appeal on merit. No, I have also collected some judgment under section 154 of the Indian Evidence Act previously. Let it be adjourned. So I
Because you see this judgment is staring on the face of.
because I that is judgment.
No, in this case, what had happened is the trial court convicted. At the appellate stage, they enter into the appellate stage. The High Court acquitted, stating that they are married, they are staying together. There is a child born out of the relationship and all. So therefore, the High Court acquitted. Supreme Court says that you can't acquit. That's not the ground. You have to see the evidence and decide it.
Yes.
Hasita will go on merit, not in the appreciation after the matrimonial relationship.
You show me if something is there for the purpose of acquittal. I can on merit I'll acquit a temple. Why to get into all this?
Yes, so without
find out some way out.
Yes, ma'am.
In between I'll put in merit finish.
Say judgment of reference.
Why to get into all these things? Technicality.
Technicality order. So I'll go.
So show me some material from the record.
Yes.
One or two material and forget about what are the material against you. Just that those things I'll forget. And the rest of the thing I'll take consideration and acquit.
Yes.
That's the best way. Because you have to save the family. Not that unnecessary. Show me. Shall I put it in the weekly list and argue it? Don't bring them. You are. You tell me what are the materials which is favoring you. Those materials I'll pick up and record in acquittal. Simple.
Section 154 of the evidence.
Whatever you have.
Yes, yes.
Whatever you have.
Very.
Because the prosecutor's evidence is against you. That's the problem. You have to get over that. Some from cross-examination, somewhere something you can point out, then and I could.
Sir.
You have to create a doubt in so far as prosecutor.
Even they say that you are rescued by police.
In that. That's the problem. But still there is a chance of acquittal. Still there is a chance of acquittal. Just see.
Sir.
Okay, mix it for final disposal. Include it in the. He is already on bail or shall I grant bail? Okay.
I am second.
Second. Connected.
Correct.
Who are you?
I have been saying active number 2. But
How are you related with accused number 1?
There.
Well, how are you related with accused number one?
I am not related.
Your friend.
They say allegation that the victim has accompanied with me as a pillion writer, and that is only allegation.
Wait, if this appellant will be acquitted, automatically you have to be acquitted. Why are you unnecessarily arguing? Wait. You are on bail or not?
Yes, I am.
Okay. Include it in the.
For 1 year, and for more than 4 months, I have suffered to see.
Okay, you will be acquitted. Don't worry. Well,
35.
Right. Appellant is a lady and convict under section 304 minor. Conviction is 10 years. I am already 6 years in custody and also my lord order dated as 10/3/26. I have been 3 years, 3 months in clean bail as my husband was expired and I am surrendering time. Also filed the surrender certificate.
Yes. It's all right. You filed some certificate. Where is the custody certificate? You have the custody period.
I'm not filed custody certificate. Not custody.
Okay. On 10/3/2026, the appellant was granted 3 months.
3 months, madam.
3 months interim bail. Entry bail. The counsel appealing for the appellant submits that after availing the interim bail, the appellant has already been surrendered, but the surrender certificate has not yet been filed.
Right.
He seeks 1 week time to file the surrender certificate. Let him do so within 1 week. In the meantime, the state council to obtain
The surrender certificate already filed.
Fine, where is that?
That is the Margaret flag. Thing is there.
Flag L, your lordship.
Flag L. The surrender certificate has already been filed. Okay. Flag L. Flag L. Let the state council obtain the custody certificate, jail conduct, as well as the antecedent approval for the appellant on the next day. Release the matter on such.
Short that being a lady, my lord.
We'll give a date. Short date. Yes.
36.
May I please? Here in this case, my lord, the appellant convicted for a period of 20 years. 20 years he is in custody.
Somebody should but yet not
A notice was issued, my lord.
Now, what about you moved the application?
Interim bail.
Interim bail for
Illness of his wife. There is a direction to take
there is a
action.
direction. Have you got the report?
said my lordship pass over because they have been they have
That's okay.
right now.
I'll pass it over. Just
Yes,
see.
ma'am.
The last order is you are supposed to get the
Yes, my lordship.
instruction regarding the wife's health.
Yes, my lord.
But tomorrow, your lordship.
Tomorrow, my lordship.
Okay, tomorrow. Yes. Tomorrow.
Didi?
37.
Tomorrow, day after, day after. Tomorrow is dedicated.
Yes.
Yes.
In this case, appellant will convicted under 6.
37?
Section 37. Under 6 of the 376 person. He is in custody nearly about 5 years later. Maintain to find the copy of the depositions.
Entry period, proceed like counsel. Notice has been issued.
Notice has been issued. Informant has already filed the wakalat.
Okay. Custody certificate and all is not there.
Yes, ma'am.
Custody certificate. Don't wait. Future one. Yes. Next. 38.
38.
Lordship, conviction under section 363, 366, 376 and read with section 6 of the POCSO Act. Lordship.
Notice,
The appellant-
notice had gone.
Notice has already gone, Lordship.
Service. Service
Yes, my lordship. They filed an objection, my lordship.
already filed.
They filed an objection.
Where is the objection? Objection is not there.
My lordship, I have.
Where is it?
They have not appeared through anyone.
It is in file.
They are just opposing the bail application by filing an affidavit. No one has appeared.
When this has not been filed.
No, my lordship, because
The original you are keeping it, file it. It is given to you.
yes, my lordship, yesterday.
You are keeping it with you, file it.
Meanwhile, custody certificate.
Notice to the victim, public informant. She appears to have given an objection in writing to the learned counsel for the state, which she has not placed it on record, and hence she seeks 1 week time to file the objections. File the objection, release the matter after the objection is filed.
Custody certificate and conduct.
Yeah.
In the meantime, custody certificate and conduct from the summons. Yes. I'll just come there.
Yes. The petitioner convicted under section 3761 IPC. Rigorous imprisonment 7 years. Out of 7 years, already 5 years, 5 months already undergone.
I have to collect the conduct and custody certificate.
5 years, 5 months out of 7 years.
Chief.
Okay. Release it to call for the report. And meanwhile, we served on the informant. 376?
171.
1. With the public to IAG. Release the matter on. Let it be on 24th. 24th.
Yes, ma'am.
Because today is father's death anniversary.
Is there any application?
No, man, sorry.
Then, yes.
Obligement.
Item 40.
40, my lordship, kindly have a glance to the order dated 13/1/2026.
In 1?
2026.
Yes.
The order is a wrong order, my lordship. And after that, the counsel for the petition appellant is not appearing. And the order is a wrong order has been passed. Because if your lordship will see on 13/1/2026 order.
In filing the IA number, the appellant in custody in connection with so.
Because in paragraph 4, my lordship.
4, huh? Counsel for the appellant submits that to the appellant.
The order was passed on 31/1/2026.
10 years.
And
10
in
years.
paragraph 4.
He's already spent almost 3 years in custody, and he has contended that since elder sister's marriage is going to be held on sunset.
Held on, my lordship, held on 24/2025, and the order was passed in 13/1/2026. And for that, he has got an interim bail for 1 month.
Maybe 26, maybe 20.
No, the card is there, my lordship. They have filed an IA and the marriage card is also there.
And has he surrendered or not?
No, my lordship. That's the problem, my lordship. And the counsel is not appearing. And if your lordship will see the next order, order dated 17/2/2026, 10/3/2026, and 21/4/2026. Taking time, my lordship.
Counsel is not appearing what? Pass it over. Thereafter, none appear for the appellant. No surrender certificate has been filed.
And if your lordship will see the IA also, the marriage card is there and it was written 24/2025.
That's all right, but why have you not pointed out to the court?
My lordship, actually, today I have seen, my lordship, but the last time
Thereafter, 5-6 hearings has.
Yes, my
Now
lordship.
today you are.
But my lordship, the file is allotted to me, then I.
Move an application.
Yes, my.
I'll issue warrant on that.
Yes, my.
Move an application. I'll release it day after tomorrow. No, yes, day after tomorrow. Release it in day. Move an application. Okay.
Yes, my lordship.
Formal application move. I'll issue warrant against him. Yes.
41.
And you must move application. Next time what will happen is somebody else will appear.
Yes.
He will have no clue. Then he'll ask for an adjournment. That is what is happening.
Fine. Yesterday, tomorrow I will file.
Yes.
Yesterday I just seen this my lordship order.
Then you move application
Yes.
instead of handing it over to anyone else. Yes.
Yes.
41. Yes.
May I please, your lordship? My lord, The present appellant is convicted for the offense 354B, my lord, and 376 read with 511 of the IPC, my lord. The maximum sentence is 5 years, my lord. The appellant is at the time of occurrence a 21-year-old and the victim is 42 years old, my lord. As per the allegation that he found the lady lonely, she tried to commit rape on her. That is the statement before PW1 is the victim, my lord. And PW10 doctor, there is no mark of violence, my lord. There is no, as per the allegation, there is nothing, my lord. PW1 is the victim in her.
You have undergone already?
My lord, I already under 1 year, 8 months, my lord, out of 5.
Out of 5 years, sir?
My lord. 21 at the time of
27/7/2022 to no, during trial only 1 month.
1 month.
Thereafter,
Thereafter, since conviction 31/2025 to till now.
yes. Show me the evidence of
My lord,
the
PW
victim.
is the IO, my lordship.
PW11 is the
That of IO. Prosecutrix. PW1.
PW1 victim, PW10 doctor.
Let us see.
PW11 doctor. I'm relying on both of them.
Because here is
The
the
cross
allegation is
examination
attempt to rape, my lordship.
and but my lord, the allegation they are stating they are bite the mouth of the accused person, but there is no injury report is there. I also examined the exhibit mark. There is also no document regarding that. There is no evidence of the attempt.
But that was confirmed by the IO. IO was saying he noticed the injury in the lips of the accused. That part is only there.
Who is the doctor?
PW11, my lord.
11. Who has examined you? Which doctor?
There is there is no evidence.
Accused person was not
Not
examined.
examined.
No, my lord.
And exhibit 5 is they have found something in the spot, my lordship, where it has happened.
But the Caesar witness turned down.
Some broken pieces of glass, bangles,
And the
broken plastic bangles,
the broken wristwatch.
1 year flower, wristwatch having blue and wholesome.
And also there is a delay in registering the FIR.
Call for the report. Huh? And I'm listing it on 1st September. Let us get the report. Your conduct has to be seen.
Man.
Your conduct. Antecedents. Okay. Yes.
42.
Much obliged, ma'am. So it is for in jail. I filed it since January. His mother is suffering from heart disease.
We got, madam.
My lordship, last order is not there, my lordship, because they have filed, but the matter was not listed.
It's a copy of the memo.
Your lordship will say the last order that it is not.
Copy was served, my lord.
An entry measure direction of relation confirmation. It was notice has not been issued.
No, my lord, it has been admitted, but so far as the interim application is concerned, it has not been listed.
Okay, where is the interim application?
Application was filed in January.
IA number?
IA number 367 of 26.
This is your mother is ailing.
Mother is ailing, and your lordship may kindly turn to page 5, the prescription.
Okay, then I'll get it verified.
Yes, your lordship may see advice referred for higher treatment patient's
No, this
condition is
application
very
was
severe.
moved on January 26. Now, 8 months.
Her condition is deteriorating.
Deteriorating, right now. On 28,
Keep it to day after tomorrow.
I'll just see, 28/1/2026, an application was moved through by the appellant seeking interim bail on the ground that his mother's health condition is mother attained what is that? Whatever you said in exactly.
My lord, advice.
The mother is ill and suffering from heart disease, and doctor has advised for better treatment. In support of the contention, the appellant has also filed certain medical documents. However, the application could not be heard in between. Senior counsel appearing for the appellant submits that in the meantime, the health condition of the mother of the appellant has already deteriorated further. In view of the same, she is insisting that the interim bail application be heard as expediently as possible. Regarding it to be submitted by the senior counsel appearing for the appellant, leaves the matter on.
Day after tomorrow.
They'll take time now. Where is the place?
Barampur.
On 18th of this month. 18th of this month. Meanwhile, the state council is to obtain instruction regarding the health condition of the mother of the appellant and verify the medical documents. Medical documents annexed to the application. Yeah.
6 books is there, notice has not been issued.
Oh, 6 POCSO is there.
Yes.
Since one of the offense involved is POCSO, notice be issued to the informant of the victim in the meantime through the IIC. Which police station is that? IIC? Police station?
Barampur.
Bhanjanagar. Bhanjanagar. IIC Bhanjanagar. Then I'll have to give little more time. 21st.
Well, so far as the interim application, there is no requirement. But so far as the main case is concerned,
let us follow the procedure because it has been pending since January.
Yes.
And
that is true.
21st. Yes.
43.
It's
gone through on the day after yesterday. The consensual relationship. Your lordship has asked me that for voluntarily pay something to the victim. Your lordship may on that day before yesterday.
Yes, my lordship, there are 2 appellants are there.
Now, what is the sentence you are asking for?
My lord, I was showing your lordship the evidence your lordship has gone through that PW1 victim PW1 is that. See, in his which he has admitted that relationship is on her will see the relationship is taken. And doctor medical report also your lordship has gone through. Then there is no adverse also than that.
What are the sentence?
Sentence your lordship on 375 and all the
376.
Everything. The 493, 470, 326, 506, 109 VC. Both the mother appellant number 2 was not there in the charge sheet. She was into the picture after the filing report.
RI for 6 months, 10 years.
10 years, sure.
How much you have undergone?
1 year already.
Only 1 year.
Yes, your lordship. Your lordship may kindly see the have a look on the evidence, your lordship. Your lordship will see PW1. Your lordship may kindly see paragraph 2 first.
Paragraph 2. PW1, huh? Yes.
When took place on sunset in the house, I had a log affair with the accused. So and so since 2 years prior to the date of occurrence.
Accused was in love with
each other.
Sure to marry me. What is the age of this girl?
At that point of time, 24 years, your lordship.
3 years.
And your lordship may, in the cross examination, if your lordship will turn, which is at page 3, your lordship, paragraph 8. Paragraph 8, your lordship. I have read up to class 9th in the English medium, but I don't know how to write and read and write Oriya. Again, I say it
paragraph?
is paragraph 8, your lordship. Lordship got it? But I don't know how to write and read. Again, I can read Oriya slightly. I had gone through the content of FR. It is true that.
Where is the custody certificate?
We had physical relationship
Do you have the custody certificate?
From the date of this conviction is on 14th
And
August.
what about during the
Trial, I was in on bail, Your Lordship.
on bail?
But now, my lordship, two appellants said the mother has got the granted a bail on 27/11/2025, but she has
Get the antecedent and
for 3 months.
antecedent date conda. Antecedent date conda.
It's not yet
Please
filed.
Why?
27.
Indian was pending.
No.
Appellant number 27/11/2025 का order है actually.
Mukesh Tandi and Josoda Tandi.
Yes, 43, my lordship.
Josoda Tandi. Josoda Tandi got the bail, huh?
Yes, on 27/11/2025.
27.
11/2025. Paragraph number 6.
You didn't press the application for appellant number 1.
Yes.
According to the present application consent so thereafter any application is filed.
No, after that application, I filed this current application which is before your lordship.
Which one?
This is
IA number?
IA number 586, your lordship.
586.
Yes.
This is the fresh application.
The fresh application.
Okay, in the fresh application, call for the status report, call for the custody certificate, and list it on 27. 27.
Yes.
Yes.
44.
Before your lordship, kindly see the last order, 10/8 to 12/26.
The appellant found for the principal sector out of the substantive sentence of 5 years, the appellant has already undergone or 2 years imprisonment, and he has also drawn the attention of his court to the evidence of PW victim and submits that the allegation, even if taken at face value, are not serious in nature and got allegations of penetrative sexual offenses. Yes.
So out of 5 years, I've already said custody near about 2 years. Only as a allegation is PW2 is the victim.
Where is the Agarwal?
Since he is not appearing, your lordship. The informant is not appearing. Your lordship also directed her to file a
Yes, because she has taken time on 5/8/2026.
Yes.
This is not appearing, huh?
Not appearing.
Madam.
And PW2 is the victim, only allegation.
Convicted under section so. Notice was issued to the informant public, the victim, on when was the notice issued? On 24/9/2025. After receipt of notice, she has engaged Babita Agarwal and Mosimi Rimjin, advocate, to oppose the bail. The counsel for the informant on 5/8/2026 sought time to file the objection to the bail plea. However, however, no objection has yet been filed on record. When the matter was taken up on 10/8/2026, it was simply adjourned in the interest of justice so as to enable the counsel for the informant to file objection to the bail plea for the appellate. Today, when the matter was taken up, none appeared for the appellant. The objection has also not been filed. Mr. Learned Counsel, Mr. Das Polda, Learned Counsel appearing for the appellant, has taken me to the evidence of PW. Who is the victim? PW?
PW2, your lordship.
PW2. PW2. PW2 admits that the allegation made against the appellants are not serious in nature, and there is no allegation of aggravated penetrative sexual offense. The victim was 14 years of age, has only alleged inter alia decoding agenda. On the day of immersion of Ganesh, immersion ceremony of Ganesh Chaturthi की Lost the FIR in writing. And what else you wanted to show? What else you wanted to show? And cross-examination?
Cross-examination, your lordship, there is no specific cross-examination. Only allegation is that he embracing on the road. That's all.
Okay. Out of sentences,
5 years.
5 years, you've undergone about?
Near about 2 years.
I don't. Out of the total substantive sentence of 5 years, what is the appellant? The appellant has already undergone about 2 years of incarceration. Therefore, Mr. Dasparada submits that pending the appeal, the sentence may be kept in suspension examination. Right? Regarding it to the nature of evidence and period of custody, and since there is no objection filed by the informant, even after repeated opportunity being afforded to have, I am inclined to suspend the sentence pending appeal, accordingly granted bail. Yes. Yes.
45. The appellant has been convicted under section 6 of POCSO and sentenced to undergo RI for 20 years. And the petitioner on bail during trial. PDOL 1 is the victim, PDOL 15 is the doctor.
Call for the 3 reports, huh? Call for the 3 reports and let the report come, huh? Yes.
It's official, my lordship.
Notice it. First taken to serve the notice on informant of the victim. Yes.
And I may pardon.
First, I'm calling for the report. Yes. Yes.
Posted to
give it it. Yes.
46.
44. Also granted by sterilization of fine.
So that is it. Yes.
6 minutes allegation, number of allegations, but in fact one allegation got proved minus 307. Used by use of minus 25, 27 of the arms are acquitted. But then there is an
only convicted under 307 and 10 years sentence.
There minus fact remains minus when the arm has that particular bullet. The police officer said that this was not subjected to any test and this report was not submitted.
Yes.
There was a ballistic report that is now being relied upon that he is sketching the evidences. No. This is the person who has done it. In spite of the fact that the father of the
how much you have undergone by
yes?
Undergone period?
But I am 1 year, almost 7 days awaiting 1 year. 7 days awaiting 1 year on the custody means after
conviction.
Before 3 months. But I will place it. I am giving this evidence affidavit, all these particular evidences, so that he can go through and find out.
In the meantime,
we will take up next week.
That for the convict submits that trial court record has come.
No, it has come, but the evidence about the total
everything is
examination and cross-examination.
He will read it from the trial court record. You take it soft copy. Why should he supply? He's in custody.
I got not that only I can supply only the evidence part.
You want to give it. It's not necessary. After the appellant be called to release the matter after you have undergone about one year. 1 year.
1 year. 1 year. It will be around 1 year. 1 year 3 months. Under trial 3 months. This is 1. 1 year means 7 days awaiting 1.
Out of 10 years. Along with the bail penalty from the concerned authority, release the matter after the report. Yes.
Fixing it, my lord.
I am calling for the report, your conduct and all, antecedent and conduct. There are antecedent and conduct.
No.
Besides your period of custody, I'm getting a report and then I'll hear it. Yes.
No,
meanwhile, you give a copy.
No, I'll give a copy. Fixing.
I'm fixing a date. I'll just see and fix a date. Okay.
47. Meet PJRC. Here the petitioner has been convicted under section 376(1) and 417 Indian Penal Code.
Yes.
And sentenced to undergo RI for 10 years. Here, if my lords will peruse the statement of the victim as well as the doctor.
I'll have to issue notice.
The FIR may kindly have a glance.
I'll have to issue notice, issue notice to the victim.
Notice.
Appearance.
You are appearing.
Appearing.
My lord, note copy of the evidence.
Copy of the evidence. Copy of the evidence. आपको क्या देंगे?
And a copy
It
of
is
the.
there. Take this soft copy.
Right. They can take
this
this.
soft copy.
Man,
Prepared. You want to file objection?
my lord.
Or sometimes. He has absolute right to file objection.
After service of notice on the informant public, the victim shown to enter a position, it's time to file objection to the bail plea of the appellant. 2 weeks time to file objection, release the matter after the objection is received on 7th of September. Yes.
Conduct as well as my lord.
Yes, in the 7th result.
Period of
11th of September.
What
This
the-
time, the custody certificate, jail conduct, and the antecedent of the appellant be also summoned from the concerned authority. Yes. What the
My lord taken up 18th, my lord.
11th?
11th.
Yes.
But it might
11th September.
Yes.
may I please. Total punishment 4 years for 8 books work.
Also is there and notice also sent, we are send the letter, but report has not finished.
1 year.
Sufficient.
No, report has not reached.
Okay. Also notice was issued to the informant of the victim while ordering 13/1/2020, but the report of service report has not been from the State Council, and he seeks 1 more week time for this
1 year or
release the matter after
1 year, 3 months out of 4 years.
Huh?
Out of 4 years, 1 year and 3 months
So,
custody.
release the matter on 27th. 27th, yes.
49.
Only.
May I please?
27th, 11th. Yes.
49 also
Schedule 2 is the victim, my lord.
is there. And we
Section
also send
10.
the notice. Around 23 to 26 interim bail is allowed.
And he has surrendered in time, my lord. I have filed IA 1007 of 2026.
No, service is complete.
No, sir, notice, sir,
Huh?
we have not received the report.
Okay. When the notice was issued?
28/1/26.
Huh? Notice was not issued. When the notice was issued?
Madam, 22/1/26.
22?
22/1/26.
Okay. Notice to the opposite party, informed of the victims, was issued by the order dated 22/1/2026. After serving, AD has been received. The service report indicates that the card is already been check back, duly served. State Council submits that the notice to be served to the IAC. No report has been received from the
I may pardon, my lord.
regarding the notice served by the IAC. Since
Noting says compliant. Noting says compliant.
Huh?
Noting says.
Yes, that's what I'm writing. Since AD has already been received, notice and the opposite party. Number 2, victim of the informant is sufficient. Is sufficient. However, not appearance on their behalf. Therefore, I appoint which gets police to appoint some young lady that is sitting there. Appoint her. Yes. I'm appointing.
Madam?
I'm appointing her. She will file objection. Yes. File objection. 50.
Madam, I may pardon another thing, my lord. Stay relation fine has not been done. I filed IA. Now I have also filed IA for bail. Out of 5 years, he is in custody. 6 punishment is 5 years. Out of 5 years, he is in custody more than 6 months. And he has surrendered in time after availing it.
Let's get that report also. Get the report.
The report and the custody certificate.
Yes, yes.
I'll short copy.
Yes. Yes.
And it's day
50.
Date.
Date I am giving it. Letter prepare 11th September.
Item 50 may please ask you. In this case, my lord, conditions scheduled for 1 part 1 and 34, my lord. And under 10 years, sentence 10 years, out of 10 years, he is in custody, my lord, more than 5 years. And last time you asked there is state council to obtain the
11/8/26 we are sending the letter, but report has not been.
got to conduct and a custodial period.
Custody and conduct.
But the custodial period had been mentioned, specifically mentioned.
10 years. Out of 10 years, you want to go on
More than 5 years.
more than 5 years.
Lordship, I am appealing in sub-item 2, but in my case, the custody certificate has already come and the conduct certificates.
What about
Our custody which was that
in second item?
25526 you had not received the custody.
No, what about 4 of 26?
It's 4 of 26.
Let us see. If he is entitled to bail, at least he will get it. Let's see.
Specifically, my lord, the second page of judgment, my lord. That is page, my lord, 15. The specifically mentioned the period of detention 4 years, 6 months and 20 days.
Already
2
there.
days, my lord. As per judgment, my lord, 1/12/25.
Let us see.
Page 14, my lord.
Let us see the front page. In the front page.
Front page, my lord. 14, page 14, answer 1.
Yeah.
Date of judgment, last, my lord.
4 years, 6 months, 22 days. And
On the date of judgment, my lord. That is 1/12.
and thereafter, after judgment, you are there in the custody.
From the
Both of them, Lord.
both of them.
That is on
1/12/25, my lord.
when impugn judgment was passed on
1/12/25.
9
months.
By the time, my lord, he was a custody.
Then again 8 months.
My lord, taken 8 months.
8 months plus
More than 5 years.
4 years. 5 years. Let us see the evidence now.
Evidence, my lord.
Yes.
So far in this case, my lord, I am pressing the fact, my lord. The deceased, my lord, who is a drug addict, my lord. He was remaining in a addiction center, my lord. Where, my lord, my friends, owner, I am the, my lord, the caretaker, my lord. On the date of occurrence, it is the family members were there in order to see the deceased, my lord. And they found the dead body lying. And thereafter, my lord, the inquest were conducted, post-mortem sent for post-mortem. Period 22 is the doctor who conducted post-mortem. And the image of the, my lord, the said home, my lord, period 6, 7, 8, and 9, my lord, they have not stated anything, they became hostile. Basing on the circumstantial evidence, my lord.
6, 7.
6, 7.
Inmates are 6.
No, 7, 8, 9,
7, 8, 9.
7, 8, 11.
9.
10, 11.
9.
10, 11.
9 also.
7, 8, 9, 10,
11.
10 and 11 are
Image of the matter they declare hostile.
inmates hostile.
They are not supported the case, madam.
Okay.
And the period 22 is the doctor, madam.
Let us see the doctor first. Let us see the doctor. Yes. ENT wala. Doctor. It's about body. Multiple bruises, huh? The back side of the body, both leg and like thick. Death is due to cardiac arrest.
Correct, madam. The cross is very clear, madam.
PW 22 cardiac
There are
arrest.
injury, madam. That is
PW 22 doctor.
Madam.
And no, there is no eyewitness.
There is no
Where from I get that he is drug addict?
The story of the
First story categorically.
Paragraph 2, madam, of the judgment.
And the conviction is based on what then?
Well, basing on the circumstances, since he was residing there, madam, the petitioner, madam,
The parents of the deceased might have.
madam, they
Who are the parents?
post-class witnesses, madam.
Who are they?
Madam, one and
Who is the informant? Who is the informant?
one.
PW 1 is the informant. Who is he?
The madam mother.
Mother. PW 1 is the
PW
One
is the informant.
informant.
Now, who is he?
Takes Sher Ali, father of the deceased.
Deceased. Wait, father.
Yes, Lord.
Father
Of the deceased.
of the deceased. Okay.
And mother of PW4.
Okay.
They are post-occupancy witness.
All are post
Immediate diffusion from addiction centers.
Chesta. Namely Chesta.
Yes, what do you say?
Yes, madam. The informant, madam.
Yes.
I have doubt upon them, so madam.
Doubt, I have seen that only. Doubt.
So remain, madam.
You can doubt anything.
Intimate for the incident, rushed the center and told me that.
What are the evidence you tell me? Doubt is not an evidence.
One inmate has said that he has killed.
Which inmate?
That has not mentioned. After some
But
time,
he has all
some
the-
inmate from the institution.
No, you say the inmate 7, 8, 9, 10, 11 you examine. Who has supported?
They are declared hostile.
Then what is that? But yes. Item
Institution.
50. If you have anything, you tell me.
That is those are the charges they are declared.
You are a drug addict. You was admitted to the center. And all the inmates have not supported your case. Doctor says cardiac arrest. And these people have undergone about 5 years. Then? Oh, granted. Yes.
Okay.
Next.
51.
Conviction under section 376 2A 763 450 363.
Yes.
Section 6 of
There.
Notice. Also is that notice. And in the meantime, all the purchase now.
The Lordship, I have filed for condonation of delay of 17.
अच्छा एडमिट एडमिशन
Stay of realization.
डिले करनो एडमिट
Stay of realization of fine.
realization of fine and issue notice. Yes.
Okay.
52.
May I please, my lord? My lord, petitioner is convicted on 23 and 34. 4-month conviction. Out of 4 months to as on today, petition number 1 4 months, my lord, already.
Sorry?
And petition number 2 out of 10 months, it is custody, my lord, 3 months, 24 days.
10 months sentence.
4 months, there are two.
Two are
One is the
husband, wife, my lord.
Two is the 10 months.
Petition number 1, wife of the petition
What
number
is the substantive sentence?
My lord, 4 months, my lord. 323, my lord.
One is the injured.
Simple injury, my lord, as per PW 4 is the doctor.
4 months will be fine of provision also. 10 months.
Out of 10 months, is 3 months, 24 days, petition number 2. But petition number 1 is as on today, 4 months, my lord, already.
Petition number 1 has undergone 13 days.
Yeah. During trial, after judgment, in custody, my lord, she is custody as on today, my lord, 4 months use.
Acha, 26 March.
Right.
26 March. Okay. Petitions are committed and so and sent in front of the from from the first page of the impugned judgment, it appears that during the trial, the appellant, Sulochana Naik, had already undergone about 13 days custody, and whereas Binod Naik undergone 7 days. Yeah, what is this? 13 days, 7 days, what is this? I don't understand.
During trial period, he is not custody.
13 days, 13 days, 7 days, 13 days. What is this? See,
during trial, after the judgment period, my lord, law and trial court reflect that during trial period he is in custody.
How much?
As on today, my lord,
No, read the impugn order. What is the meaning of this? You tell me.
I mean,
Page 2 of the impugn judgment.
my lord,
Just see the right side column.
13/3/2022 to
No, end.
13 days. Thereafter he released on bail.
13 days means it is 26 days.
26 days, as on judgment, my lord. 26 days in custody. Thereafter, after judgment, there
22 days. Up to 20 days. We know the friend is 26 days. After the impugn judgment was passed on 26 March 2026, the appellants were taken into custody. You are in custody.
now
Taken into custody. Therefore, therefore about how much? 3 months.
petitioner number 1, as on today 4 months he used.
4 months, okay. And therefore, the petitioner number 1.
Petitioner number 2, 3 months or 2 days.
Has already been incarcerated for roughly 4 months, sort of substantive sentence of 10 months, whereas Vinod Naik, appellant Vinod Naik has also undergone 3 months out of 10 months. Regarding head to nature of allegation and period of custody so also, since the appeal is not likely to hurt in your future, granted. Yes.
53. Informant already appeared in this matter in last. That is.
Yes.
The maximum sentence was at 67 means in this case. 5 years.
5 years.
Yes.
Yes.
Operative person of the my lord. Page 39 of the my appeal.
Yes.
Operative person of the judgment. In the last 4 line matter.
It's all right, 5 years.
Yes.
Go ahead.
Yes.
Huh.
That is my lord. Important thing is my lord, the deposition of IO my lord, PW9.
PW9.
Yes, ma'am.
Yes.
In the cross examination my lord.
Yes. Who is PW9?
The IO.
First, tell me the real evidence. IO is not the witness.
PW3 is
The
the
incident.
victim.
Huh?
PW3 is the victim.
PW3 is the victim. Read PW3 first.
Only allegation of circulation. The PW3 stated.
Have you prepared or not?
Yes.
Yes, my lord.
Then why don't you tell me?
PW3 stated, I am reading, madam. I am the sub-item, I am reading.
Yes.
The incident took place in the year 2019.
Yes.
When I was reading in class X, I was using the phone number so-and-so of my father. Accused Dinesh Patra gave message in that phone about his address. That is, he belongs to village Durgabedi. He requested me to love him, saying that he loves me. So love developed between us and I reciprocated to his request. From the year 2020, myself and the accused Dinesh Patra talked with each other from my mobile phone number so-and-so. Suddenly accused
Dinesh Patra told me
over my phone to send my nude photos and immediately.
Whether these photographs are seized?
No photographs are seized. And the victim stated that the PW5, he stated one person accused showed the nude photos of the victim to her, the PW5. And from the PW5, she came to know that her video has been viral. The victim herself stated that she seen the nude photo from the PW6 who was Prakash Kumar Naik. That Prakash Kumar Naik turned hostile. The IO stated that he has not seized any nude photos.
What PW5 says? PW5?
PW5.
If you Jai Krishna Behra called me outside and showed me the videograph of Pratikya and showed me, Pratikya came back, then PW5 supports.
PW not support. PW5 through PW5, the victim came to know that her video has been.
PW5 support the prosecution case.
Again, PW5 support the prosecution.
Yes. And she says in between, just see, accused Jayakrishna Behra called me outside and showed me the videograph of Pratik. And
Say
told me so.
My lord, she showed the video and the nude photo from Jaikrishna, my lord, from me, my lord. But there is no circulation part is there, my lord. She is not stated anything
That
about
you are not arguing appeal. That will see.
Another thing is, my lord.
That will see. What?
Another thing, my lord, in the
video, the nude photographs or videos, nothing is recovered.
Not seized, my lord, tainted. I have categorically stated in the cross-examination first line, lord. PW9, my lord.
PW9? But
I have
not seized any photograph. Yes.
There no clarity.
My lord, during the trial, my lord, the present applicant is, my lord, in bail, and that period he was around 3 months he was in custody.
Total period now?
Total period is not more than 6 months.
Sent.
Out of?
5 years.
Then call for the report. Antecedent of the execution. Antecedent of report as well as your antecedent execution, whether you have done this kind of thing, the other girls or not. Let us see. Let the report come and list it on yes.
Stay relation finder.
Stay relation.
54. Date may be fixed, my lord. So
date I have fixed. Yes. 9th.
54 is there is the SCST Act is there, but we are sending the letter, but the function IIC only send the VNAMA, but there is not giving the report that they have received the
VNAMA signed by the victim.
That victim. That VNAMA signed by the victim.
Then give it to someone. Then Mr. Mahapatra, take it. Sign the Vakalatana. Give it. Sign the Vakalatana and file. Pursuant the notice dated 27/7/2026. Notice on the informant has already been served through the IIC, and the victim public informant has issued Vakalatnama to appoint Yes, Nandramana, who is representing the court, is requested to appear he has filed the in the court, which is taken on record. The soft copy of the TCR being supplied to him and release the matter. When do you want? When is the sentence?
Talk to your son.
20 years. Okay. Release the matter. 18 September. 18 September. Do you take soft copy? Yes. 55. And Mr. Mohandaman's name be reflected in this call list. Yes. Yes. Phone number which is FIQ. Phone number. Yes. Delay of 120 days. Delay. 120 days. Unknown. Yes. Call for. Yes. Next. Yes. 56. 56. Yes.
So for the conviction is concerned,
SCST.
Four of the SCST.
Sentence?
Period of 6 months.
6 months.
6 months. And the 89 fee has been extended by the trial court. In the meantime, what are the trial court has been pleased to issue NBW against the present officer. That's why also the IO has been fined to.
Nay, what about the service?
The notice.
Notice? Third.
There's no notice option.
Huh?
Yes, notice option. I am giving the report.
Served or not?
Yes, sir.
Yes. And pursuant to the order dated, when 6 month, when your interim or bail is expiring?
Interim bill, so what the appeal period is concerned, the appeal expires on 4/8/2026. So for the appeal period is concerned, the conviction was
Warrant has been, now warrant has been issued.
Yes.
No warrant has been issued. Okay, pursuant to the order dated 7/8/2026, the informant of the victim has already been served with the notice of the application for bail moved by the appellant. Despite service, none has appeared for and therefore some junior use the junior lawyer. So is appointed as a magistrate, pursue the court, brings the matter tomorrow. Because service is complete.
Yes, sir.
Somebody has to appear. 6 month sentence, I'll allow it. But to complete the formality, whoever is the junior most in the, who is appearing, is engaged, junior most. And give the soft copies. Last appoint and give. Who is the junior most? Other girl is junior most. Call her. Madam, you appear. And in the lunch time, you read the file. Tomorrow I am taking up this matter. Okay. Tomorrow, huh? Tomorrow. Yes.
57.
JCRL. Right.
Lordship, for condemnation of delay.
Sorry?
JCRL, my lord, on the last occasion, my lordship had directed, while engaging me as the amicus, had directed to file I for condoning the delay, my lord.
Or you filed it?
Yes, my lord.
Delay condone. Delay condone admit. Delay condone admit. And which notice? Yes, also. Yes.
Lordship, 6 folks of 20 years conviction.
Yes, I am issuing notice to.
Okay.
For the reasons stated in the application, delay is condoned and admit. Call for the. Is there any fine?
Yes, ma'am.
Fine. Stay realized. Fine. Yes.
50,000.
50,000 fine. 50,000
shop. Yes. Yes.
58. Number 1. 58 times for the petitioner.
Opposite party.
Yes, madam. Here's the read petitioner.
These are all admission hearing. Okay. Based on the yes.
Yes. Against the order of this Consumer District Forum, the read petition has been filed on compelling situation. Facts of the case is like this. The present petitioner
is challenging which order? The
order passed by the District Forum. There's an appeal forum. Still, by bypassing that forum, I invoke this jurisdiction of this honorable court. The reason behind, petitioner is a doctor, he's a surgeon.
Merit will
no. What promulgated me to file the writ, bypassing the forum, that is I'm satisfied.
Yes.
Otherwise, the appeal forum is there.
Yes.
The reason must be there. He's a practitioner, he's a surgeon. In 2017, during surgery, after surgery of abdomen, in a laparoscopic surgery, a patient died. After 2 years of his death, his wife filed a consumer case before the State District Forum of Cuttack. That CC case was dismissed for non-execution. So I remained silent. Thereafter, his wife filed a review petition before that. That review is also dismissed.
Who is there?
That review is also dismissed. On that, thereafter, I remained silent because to my knowledge, everything is dismissed. Thereafter, she filed an appeal before the State Forum against the order of dismissal of the review.
Yes.
State Forum, without issuing notice to the opposite party on the admission stage, remanded the matter to the District Forum, saying that you decide the matter on merit within 45 days. Now the problem comes. In District Forum, I was never noticed, though there is an order, notice has been issued. I am showing that orders.
All these things all right, but why can't you say all these things in the appellate forum?
Yes.
Who stopped you?
Because I was supposed to appear before the district forum. I have to say, I have
Oh,
to
it's
say.
all right. You tell everything before the.
Because
Is there any bar under any law that you can't tell all the things?
I'm
in the appellate
submitting.
forum?
Yes, I'm submitting.
Writ jurisdiction are very special jurisdiction. Why?
Violation of principle of natural
Then the
justice.
tribunals had to be abandoned then.
Lordship may direct the district.
In every such cases, there is some story.
I have to deposit 50%, sir.
You tell me that. You move application for waiver. Special circumstances it can be waived.
Because
I'll record that. I'll record that.
Because no notice.
This is a medical negligence case. You have a good case.
No, I have a point there.
No, I am not on merit.
Because the expert committee has already given.
I am not on merit, sir. You may have a very good case, no doubt about it. And you have a special circumstances which you have merited.
Expert committee.
That itself is the ground. Then you are basically trying to say that since there is a waiver condition, so therefore I will not go there. You exercise jurisdiction 226.
No, that is not my ground. My ground
That
is
is only
only noticed.
Yes, that you can tell the state consumer forum.
For that I have to deposit. Sir.
Again you are coming to there only. Because of the waiver condition you are coming here.
And the expert committee has
the idea of 226.
Expert committee has given report that they have.
I am not going to.
If I would have been noticed, I would have said that the report of the expert committee. So I didn't get opportunity to put that report there.
You are absolutely correct there. But all these things is open for you to urge before the
can be waived petition, then
waiver petition you moved. In the special circumstances that has to be considered.
Lordship, page 41 of my counter. So my friend is referring.
See, this is basically an ex parte order.
No, my lord. 41, here the notice has been issued. Lordship, page 41 of my counter.
Yes.
Having not contested this.
Not counter. You show me from the order.
Yes. Page 41.
Page 22 is the entire order.
In the order, just show me.
The order of the district commission, which I have annexed to my counter, and annexure B by 1.
B by 1.
B by 1. Page starting from page 39, page 41 the relevant portion.
Yes.
Notice has been issued. There it is.
Having not contested this case, the OPs were set ex parte, and even though the case being remanded back to this commission from the Honorable State Consumer Dispute Commission Orissa Cuttack, opportunities were given to the OPs to file the written portion and contest this case as per the direction of the Honorable State Commission, but still then the OPs had not appeared nor had any contested this case.
No notice has been issued. I have verified the file.
And
you might have verified. Credit court will go into this thing and see the record and find whether it is shared or not.
The order sheets.
And this is the appellate court's jurisdiction.
That
whether proper service is there or not.
Yes.
Writ court will go into all this.
No,
I'll call for the record
but this court can see the order sheets, entire order sheets. In the
order sheet shows, you go and file an appeal and
give that observation.
I'll give that observation.
Since last 3 years, I am not getting anything. Though I have been awarded order.
That I don't know. Is there any stay operating here?
Yes, my lord, yes.
Okay, I'll pass an order. Give it to me. I'll pass detail orders. Yes.
59.
Another case was under the Consumer Protection Act, Corporate Development Authority that yes, the approach, the opposite party approach.
You're telling me which order?
So the order. Your may submit only small thing matters. I claim matters. I got that judgment. But after the consumer case put up from 2023 to 45, some case and all this. When High Court can interfere, when High Court cannot interfere. A frame matters can be taken up next to generate different note and will be passed.
What note? District Consumer Forum order you are challenging?
District consumer, I said it is not maintainable. State consumer, I said that it is not maintainable.
See now.
That they have come.
Then go to National Commission and tell all these things.
That is government, my humble contention, that what is done by the Supreme Court, I will bring it to me.
How El Chandra will come, you tell me? How El Chandra will help you?
That question is not that one. Question is that.
You said El Chandra. You tell me El Chandra, how El Chandra will help you?
No. The Sampo and all, number of decisions are there. I will bring it.
You give me one. I don't think you
If it is
can.
not so, minors, I ask so, minors, if it is not so, then I will go to the another.
Come at 2 o'clock. Tell me. Come at 2 o'clock. See, you say judgment. I don't think any judgment will help
2
you.
o'clock, minors, another matter, things must maybe taken up day after tomorrow also. I can bring it.
Okay, day after tomorrow.
Day
Day
after
after.
tomorrow or next
See,
week.
these matters are unnecessary lingering. Nothing else.
That's no problem. That's no problem.
This is the last chance that were given, opportunity that were given by this honorable court, and no further argument to be given. This is
No, that I have indicated. Last order I have indicated.
Yes,
That's exactly my.
yes, my right.
Yes, taken up for Friday. No problem.
No, there is no problem, but I have indicated it is very clear that no further adjournment shall be granted.
Order number 3 passed by this honorable court. No further adjournment to be given.
Custom.
Yes.
I don't dispute on
With
this.
the end to
It's a point of law.
Yes.
I am appraising it. Minors have heard it.
What?
Now we wanted that some judgment to be referred to some point.
So then if there is an indication that no further adjournment will be
That is not
granted,
on.
Right there, minors. No.
Yes, one alternate immediately available to
you are seeking adjournment for Friday.
No, minors. Keep it part out, minors. Minors may keep it part out, minors. It cannot be adjourned, but may keep it part out, minors.
Oh, see, the problem is this matter is getting adjourned time to time.
Yes.
Can you please stop?
My lord, yes, ma'am.
Time to time it adjourned.
Don't dispute on these minors. Only thing is the day after tomorrow I will bring the judgment and that day after.
Last time Mr. Pradhan appeared.
Yes,
I have indicated that no further adjournment. Now a senior counsel comes and asks for time.
No question of asking for time, minors. Question is that minors I collected some documents, judgment, and I bring all the judgment to assist minors.
Okay, day after
That is
tomorrow.
what.
Day after tomorrow. Yes. Yes.
Continue day after tomorrow so that we can.
Yes.
Item 60.
40.
40, what happened?
My lordship, I have pointed that.
I kept it for day after tomorrow.
Yes, ma'am.
Item 60 also there.
Kept it.
Your lordships, item 60 we heard after lunch.
No, I have not said that.
Yes.
I have not passed any advice.
Personal difference, item 60 may be kept on day after tomorrow.
Your lordships,
tomorrow.
your lordships, I 60 there is a very small issue involved in this matter. Only the same thing.
You are appearing for whom?
For the
I'm appearing for the respondent. I'm appearing for the 12. I'm appearing for the
day after
12.
tomorrow I am ready.
Your lordships.
I understand what he's saying. Yes. Yes.
Your lordship, this is with respect to 12 complainants who are senior citizens. This
What do you want? You tell me. Are you interested to argue?
Your lordships will hear me at 2 o'clock, please.
Yes.
Day after tomorrow, I am saying I am at the any time.
You are for appellant.
Yeah, I am for the petitioner.
Your lordship, the stay has been granted.
Yes, there is a stay.
Stay.
He is opposing.
I am last day.
And day after tomorrow, I should have. See, now she has given a judgment.
Yes, my lordship, that was.
Which is directly against you.
Yes.
Give that judgment.
Yes, my lordship.
That's directly against you. Written judgment. Same, sir. Same situation. The Supreme Court says you can't do. I have done it, but see the judgment now. Verify thereafter you deal with
This
that.
judgment was so moto taken by the Supreme Court.
Yes.
The High Court was interfering in the conviction. That's why the.
Convicted by the trial court, High Court taking into consideration that the victim has married with the accused of the trial court. That's what. Next week. Yes.
I mean, paragraph. Item.
That is why, see, unless you satisfy me, then the question of they are coming or not. See, marriage certificate is there. It is registered marriage. So they may not come also. Oh. The petitioner is in bail or not? Huh? The best thing is I will grant bail.
Yes.
And let it be pending for years together. It will be there. They will be settled by that time. Give regular bail. Why next week? Right now I will give bail. Huh? Sorry?
They are not filed in.
File the IA, come tomorrow. Come with an IA. Come with an IA, I'll grant bail. The best thing is, they are married, at least he'll get regular bail. And when the appeal will come, we'll see. The law might have been changed also. Who knows? I'll give regular bail. Come tomorrow. Come with the application. Don't bring them. Okay. Come with them. Just move a formal application today. Tomorrow I'll take it up, mention it, I'll grant regular bail. Okay. And along with the bail application, the marriage certificate also has to be placed. Okay.
Yeah.
Yes.
Item 59, the first time I have mentioned to take it up today. From the custody certificate I have found, he has been absconded, so 8 years, 9 months only, out of 10 years conviction.
Out of 10 years. 8 years, 9 months.
But it was my submission that more than 11 years and a half months was there. But in fact, after releasing on interim bail, he has absconded. That's why.
Now he is absconding now.
No, he is in custody.
After warrant was issued, he was.
Yes, he has been taken custody. Let him take an usual course.
Absconded offense is?
NDPS Act. 10 years conviction under 10 years conviction.
Item number you said?
59.
Huh? Weekly 59. Get a custody case with that antecedent and let the antecedent also be.
Yes, ma'am.
Okay. Yes, sir. 59 the weekly, sir. Yes. Yes.
Item 26.
My main pointed out that this is Foxtrot and notice has not been issued.
It has already been admitted?
Yes, sir, that has been admitted. It has been confirmed, everything has been done.
Okay.
I am inside the custody since 7/4/2016.
Okay. Call for one of your
PW, the team at PW 16 in the government.
has been convicted for offense interception so. Issue notice to the comment of the victim. Says to the IAC, release the matter in the second week. That is on 16th of September. Yes.
So another thing that
I've already done it. Yes.
Okay.
Item 60. 60, Your Lordship. I have praying for time for tomorrow, Your Lordship. Only.
And tomorrow may not be possible, sir. But
My learned senior is actually not. So tomorrow I can argue.
He is opposing what to do.
I am ready for tomorrow, Your Lordship. Tomorrow
You may be ready for tomorrow, but he is opposing. Tomorrow I am not ready. Because my board
great
will not-
difficulty this matter has listed.
Tomorrow is a dedicated bench.
The day after tomorrow also I have no issue. Your Lord. Day after tomorrow.
What is this matter is?
I am challenging the order of National Consumer Dispute Commission, where the single technical member has passed the judgment. Technical member has passed the judgment. I am challenging the legality of the order and I appeal before the order of the NCSC before the Honorable Apex Court. But there has been some judgments of the Apex Courts which says that when there has been order passed by a single judge.
Why don't you file SLP?
No, Your Lordship, I am relying on some judgments. Your Lordship, I have cited some memo citations.
May I submit something?
Yes.
Your Lordship, this is a original complaint filed by 12 of the petitioner before the National Commission. There is a statutory appeal, section 23, go to the...
Yes, 23 is there, yes.
Yes, Your Lordship. Only Supreme Court has in a revision and appeal has stated that 227 can be maintainable Justice Party wala judgment universal sample.
Yes,
But with respect to this 23, they have not stated anything, Your Lordship. They have stated...
Where is the State Commission order? Let us see.
Your Lordship, at page number...
It's National Commission order. State Commission order.
Page number... Relevant
original
page
complaint
number 43. Page number 43.
Yes.
43, it has been signed by the technical member. Your Lordship, the last part, Your Lordship may be seen.
43.
Page number 43. The judgment starts from page number 27, but relevant portion is at page number 43. Presiding member Binay Kumar. Your Lordship, please.
Is it heard by both the...
Both the judges, but judgment was passed by single judge.
No, where is the judgment? Let's see.
Judgment starts from page number 27.
27.
Yes, Lordship.
Annexure?
Annexure 1.
Annexure 1.
Relevant is Annex 25, Your Lordship. 25. And relevant portion is at page 43.
What is 25? What is 25?
It is a cost item.
Cost item, okay.
Cost item. Judgment technically starts from 27.
And it's heard by this single member.
It was heard by the division bench, but judgment was passed by single member. And
Where is division bench? Just see 29, page 29.
Page 20.
Honorable Vinay Kumar, presiding member.
Yes,
That's all.
technical member, Your Lordship.
Whatever, but why do you say that it is passed by, heard by division two judge?
But in the previous date, it was heard by.
Maybe previous, on the date when it was, order was passed, that time this single member has passed.
Your Lordship.
The technical member.
Your Lordship.
Where is the bar under the rules?
Your Lordship, I am relying some judgments, Your Lordship. I am memo.
Under the rules, you tell me where is the
Your
bar.
Lordship, on that has been relied on the judgment.
Many complaints are being disposed of by a single member now.
No, Your Lordship.
And now the technical members are presiding.
Your Lordship.
The judicial members are normal members.
Flag R, please, Your Lordship. I request Your Lordship.
There is no legal bar.
Your Lordship, flag R, I have relied some judgments, Your
Yes,
Lordship.
flag are you can file
Your Lordship, I am relying.
section 23 appeal you can file.
Your Lordship.
Who stops you?
Page number 9, flag R. I am just.
Yes.
Normally, this court does not entertain writ petition when alternate remedy is available to the petitioner. But in the issue, the present case is as to whether a member sitting singly can pass a judgment when the rules specifically provide that the composition of bench must be minimum 2. Moreover, this issue has been attended finally.
No, this rule has already been amended, sir.
That matter has been remanded. Am I correct?
Amended. The rule has been amended.
No.
Check the rule.
No, but
Rule has already been amended.
And
that time the rule was like that.
that has been
At one point, let us see the check whether in the check who has signed.
But it has been stated in the complaint that Mr. Karthik had received the check. Page number 22.
Yes, Mr. Raut.
My lords, I am seeking 1 week time, my lords. Matter of 2023.
India Mart has nothing to do with this transaction. It is Siva Appliances, the proprietorship on, for which one Karthik has issued the check. That's what you have said in your complaint.
My lords, actually, my lords, matter of 2023, and I have misplaced my file for which, my lords, I need some.
It's not a case of vicarious liability. It has nothing to do with your transaction with Siva.
Your lordship may adjourn or your lordship may pass order if it is so correct.
It's a very simple case, but I have supported with any more honorable exposed judgments.
On facts in the complaint, if you read the complaint itself, it is very clear. Siva Appliances must be your dealer.
We are the intermediary between the business to business platforms. Like the dealers, they are advertising, basically the advertisement platform. The business like the Siba Appliances has posted their advertisement that we are selling TVs, and the third person who is intending to purchase that, placing the order through our.
Okay, because he is not there, I can't do it. I will list it on 12th. Sorry, I'll list it on 19th. 19th of this month. 20th is not possible. It would be either let it be 24th. 24th. Last opportunity. 24th.
67.
For the last quarter number, the government council for office part number 2 had to station argument.
Yes. Yes.
The article was directed to hear me on the point. The CLM sees its assailed order taking cognizance. order taking cognizance, and I've gone through the contents of the complaint petition as well as the statement recorded, including the given victim under section 202. They have stated against the present petitioner relating to the allegation relating to the atrocities and the misbehavior attributed to them. And at the outset, my lordship's judgment.
So that is not, that is unfortunate, that is.
The friend of girl and she gives evidence to the court. What to
We
do?
have also annexed an old FIR at annexures 6 and 7 instituted by the mother against the present police. What I'm trying to suggest is there has been a prior NBT in which the previous FIR has resulted in.
Prior enmity or not, those things at this stage I can't go into. Whether cognizance order is correct or not, that has to be seen. For that, I have to see what is the complaint in 200 and 202 inquiry, what is the statement recorded. If prima facie case is made out, cognizance is taken. Thereafter, whatever defense you have, earlier it was filed, it is a malicious attempt on their part and all. These are the things you have to prove in the trial.
And discharge. They can file discharge.
Whether you can file all discharge application.
Yes, your lordship has
as advised.
Yes.
Yeah, that case cycle.
Not day after tomorrow. Day after tomorrow. Ready to be on 20.
Black blood.
Yes.
68.
This is regarding payment of maintenance. I am for the opposite party. Payment of maintenance, my lord. My lord, page.
Yes.
Yes, my lord. Page 22.
It's 22.
My lord. Mother 20.
NBW has been issued.
Yes. Against that NBW, when I filed the execution case, against that NBW, it's come an interim order, has taken the interim order. Since 2021, he has not paid only except 60,000. He has not paid a single amount, my lord.
I will cancel NBW, go and appear, whatever you want to do, right?
My lord.
Go and appear before court. Why should I interfere? Why should I enter into merits at all? I'll set aside the NBW and go and appear, sir. Go and appear before the court.
My lord. I am sending.
Give me the date when you are going to appear. Yeah, I will record your undertaking and.
I have filed 2 cases, 2 executions more. He is not receiving the notice. So in the same address I am sending, he is not receiving. My lord, may fix the date and you will appear.
You go and appear.
Yes.
What was the initial order?
Initial order is
For which? Where is that order?
page 22, my lord.
22. Page 20.
3,000 for mother, 2,000 for child. The initial order for to be paid from 17 to 2021.
No. Annexure?
Annexure 2, my lord.
Annexure 2. Okay. Annexure 2. 125 order. No, I will not go into minutes. You go and appear, right on. This is an petition arising out of a proceeding initiated by opposite party. Yeah? You are for opposite party.
No.
Opposite parties under section 125 CRPC seeking maintenance. By the order dated 7/6/2023, the Judge Family Court Bhubaneswar, while allowing criminal proceeding number 36 of 2021, directed the petitioner to pay rupees 5,000.
3,000 mother, 2,000 baht. 3,000 mother, 2,000 daughter.
5,000, total 5,000 rupees per month to the opposite parties. Thereafter, what happened? You
That
move
what is,
application.
that was the order was to be given effect from 17th February 2021.
The order was directed to be given effective from 17 to 2021. Thereafter, you move application.
Yes, my lord, page 16.
Page 16. The respondents have initiated an criminal execution petition 83 of 2023, seeking execution of the aforementioned order passed by the family judge Bhubaneswar. In the state of execution proceedings, since the petitioner did not appear before the family judge family court Bhubaneswar, NBW has been issued.
Page 14.
Right? Order dated?
Page 14, 20th March 2024.
20 March 2024. Agreed by the same, the petitioner has approached this court. When the matter was heard, when the counsel for the parties are heard, Mr. So-and-so appearing for the petitioner on instruction from his client submits that the petitioner shall appear before the court family judge Bhubaneswar in execution number so-and-so on you tell me on or before
September, because my
okay 10th September on not before 10th September 2026 and seek remedy available to him under law. Taking the undertaking given by the counsel for the petitioner on record, the present petition is allowed. The impugn order is the execution of the order dated
March
5 what is that 20th March 2024 issuing NBW shall be kept in events till 10th of September 2020, subject to the petitioner appearing before the court and resorting to the remedy available to him under law. With this observation, the petition is allowed, partly allowed. Go and appear and do whatever you want to do. Yes.
69.
One after another. Yes. Yes. 13/7/20. Yes.
Planet counsel for the petition opposite party express their desire to express the possibility of an amicable settlement of the dispute between the parties through court mediation. Accordingly, the petitioner and the opposite
Interim order without disclosing that there is order passed by this court in a connected matter. When by the time when the interim order was passed, whether this court was made aware that this the earlier proceeding there is an order. Show me that on that day. On 17 to 2025, when I passed this order, you have disclosed this fact.
No, after. Sorry.
That is the mistake. So therefore, you.
Sir, ignorant of my duty.
I am not, madam. I am not talking about you. I am talking about your client. Your client earlier approached for quashing of the FIR. Some order was passed.
That he was not aware.
Not complied. Thereafter, charge sheet was filed. Thereafter, cognizance is taken. You came to the court challenging the cognizance and you didn't disclose about the earlier proceeding. Got a stay. When the other side comes and pointing out and you say that no, I'll comply now. You comply the order. Comply the order. Certificate also not given. Again, you are saying I am not aware. I am not talking about you, the counsel. I am talking about your conduct of your client. This will not work. Shall I issue warrant or you surrender yourself? Day after, come day after, surrender. Whatever, I am not on the. Where is the application? You should have moved an application saying that this has happened, that happened. See, this. No. Why should the court will be under your mercy? The 2024 order. 6/5/2024 order. Today you are in favor. And the police will go and pick you up. Don't worry. You will be put in the hospital. Don't worry. That also I'll do. Nothing doing. Nothing. No, no. You have to respect the court's order.
I'm saying
Day after tomorrow, sir.
File a medical application. That is what I'm feeling.
You withdraw this petition and surrender also. Surrender also.
That petitioner also is not done for filing application. Can you have the petitioner itself? Affidavit person, his signature is totally different. He differs with us.
No, I think withdrawal will also be. He's trying to play mischief with the court. Let him surrender. First, let him surrender. Surrender by 20th August. 20th I'll take it up. Registry party, learned counsel appearing for the petitioner submits that pursuant to the order dated 6/5/2024 and 24/7/2024 passed in CRLMC number 1036 of 2024. Her client would be surrendering before the court and file a surrender certificate. Surrender certificate on or before 20th of this month. 20th of this month. Release the matter on 20th. Release the matter. You surrender by that and file surrender certificate. Then I'll hear it. Yes.
Item 17.
No, please.
Your vendor and vendee in respect of the registered document have been indicated on the ground that they are
Vigilance.
government.
Vigilance department is there. Here there.
Initially, this case was the registered instrument was registered in the year 2000.
What are you challenging?
I am challenging the discharge application dated 15/3/2024.
Your discharge application has been turned down.
Please turn down.
Turned down. Yes.
Absolutely, there is no case without the extreme time. Because there is a mechanism prescribed under the Stamp Act. How the deficient stamp duty will be recovered if anything happens during the registration of the document. The sending was executed by petitioner 1 in favor of petitioner 4. And initially the FIR was registered against 3 persons. Registered, publisher, lead clerk and the clerk. They connived each other. I think a bench clerk. They connived each other. There were government sustained a huge loss of 30 lakhs. I was never asked by them. Then investigation was carried out and matter was referred to sub-collector as per the Stamp Act under section 47A. And when that was pending, I was implicated in this case on the ground that I have not paid the stamp duty despite of the determination made by the court. In fact, I approached this honorable court and matter is now pending with regard to determination of that. That is pending. Exactly, my lord, the same case forward by
Now, this is an isolated case. The charge sheet is filed against all the registrar and all.
Initially, case was registered against 3 government officials. Subsequently, these private persons were implicated.
All the private persons. How many cases like this?
Only one case.
Only one.
Only one case. Other these 2 petitioners were implicated, and ultimately the sub-collector, who is the prime accused, he was acquitted because no sanction was taken. Subsequently, another accused, the head clerk, who is supposed to do all these calculations, he is also dead. I am implicated because 120. 120, there is absolutely no material to establish that we have connived each other because I am suffering.
When the instrument was registered?
2007.
And when it was referred to stamp?
2010.
Then after the FIR? After the FIR? After the FIR, that's the problem. It's not earlier to the FIR.
Not earlier. No, sorry. I'm sure exactly.
When it was referred to the stamp collector, with deficit of ad valorem stamp duty, then it has to refer to the stamp collector. Stamp collector will calculate and impose penalty and all consequences. That is the procedure prescribed. And what is the criminality into it? That has to be seen.
How I am implicated? There is absolutely no material. This was my friend to us.
Yes, sir.
I have given a written note of submission allowing all.
Yes, sir.
Both the petition of lordship, my lords.
And particularly when the registrar has not been given sanction.
Lords, at the outset,
Homicide case is not made out against the registrar. If the registrar, the principal accused, who has registered the document, and if against him the sanction is not granted, how will you sustain 120B?
Lords, at the outset, my lord, let me start where lordship put that question, my lords. Who are the petitioners? I put that question to myself. The petitioner, both the petitioners are the co-conspirators in the main object of conspiracy.
With whom? Who is the main accused?
Well, I'm placing it. My lord, my first submission is petitioners, both the petitioners are co-conspirators in the main object of conspiracy, my lords. And the conspiracy, because of there is unanimity of mind or unity of objects, my lord, or subject, and who are the players in the game, lords. Before I place the lords, I prepared a 2 pages note, the factual aspects, not the legal aspect. Lordship, I will not place the entire thing. It requires some amount of polishing. I will polish it. Lordship, turn to para 4 notes. The para 4, Lordship wanted certain dates, to my learned friends. Para 4 is that Kirtan Kumar Patra executed power of attorney in favor of the Bharati Patra, who is the petitioner of Lordship, on 21st for 2006, my lord. That's a power of attorney by virtue of which, my lord, the petitioner, Sekirtan Para 5, Sekirtan Patra executed. Thereafter, the same person who executed that, had given that power of attorney has cancelled that one. What is the date? The date is 11/10/2006. Let's turn to the my lords, next page, my lords. After cancellation that particular power, on 31st/10/2006, 31st/10, same month, a few days after, my lords, Bharati Patra executed a cell deed bearing number so-and-so in favor of the daughter Sri so-and-so for the land of so-and-so, putting the value 37,000, which is less than the market value, my lords, which has been identified so-and-so. Lords, we'll skip all those things, my lord. Lords, we'll turn to next page, my lord. No, Lordship, I'm just concerned about para 9, my lords. On 7/8/2007, after registration of the document, now things has been registered, my lords, in a clandestine manner, my lord. Then what happened thereafter, my lord? Lords, see the conducts. On 7/8/2007, after registration of the document, the fact of undervaluation was pointed out by the dealing clerk, head clerk, without any endorsement undervaluation on the body of the document, and obtaining the signature of the party on the document, refer the document to the collected stamp Punjab for revelation the deficit stamp duty rupees 27,58,290 and registration fees 5,01,500. In total, minutes, the amount was the amount was 32,59,799. That's the loss. Lords, we can.
What is the loss?
Lords, we can turn to the next 2 lines.
You penalize him if the valuation is less. They are liable for penalty.
Lord, the last 2 lines clarifies that.
Yes.
Lords, we can see the contents. The Lords, Lords, we turn to a certificate for realization of the deficit stamp duty registration fees. They also stated against the claimant, and that was also avoided by the claimant. However, on the basis of certificate copy of RSD so-and-so supplied by the sub-registrar office to the claimant, he could manage to mutate the land. Thereafter, it was muted. And Lord, it didn't, Lords, we can turn to the same materials facts out of the charge sheet was placed in the input orders. Lords, you can turn to page 20, Lords. On the basis of that, he also muted the lands. Lords, you turn to page 20, Lords. The material, what are the materials at the time of constitutional discharge application? The charge sheet, my lord. What are the materials placed before the London Special Court, my lords, which disclose grave suspicion, my lord. Lords, we turn to page 20, my lords. Lords, we turn to the first, Lords, we leave the first 10 lines, my lord. The line starts, my lord. The petitioner, namely Bharati Patra. I hope you also got it, Lords. Lords, we can, from the page 20, Lords, leave the first 10 lines. In the middle, the line starts. The petitioner, namely Bharati Patra, had executed registration of deed of height so-and-so, even after cancellation of power of attorney. Besides that, the document was presented with the sub-registrar by the dealing clerk,
without valuation clerk valuation chart, the separation of the existing chart rate and grossly violating the contents of the circular number so and so, my lords.
And who is supposed to see the chart, rate chart? Circle rate.
Definitely, she has no role to play. Lords, you can.
And why have you not given sanction to prosecute the registrar?
I'll just answer this, my lord. Lords, you can be judgment. I'll place the 2 lines.
What is this kind of?
I agree, my lord. The petitioner has no role with regard to this kind of, not following the circular and all this thing. I agree, my lords. But they work in tandem, my lords.
Tandem with whom, sir?
I'm coming to the. I'll answer this one. Lords, you can turn to the last time, lords. What are the material placed before the which disclose great expression after the fact of undervaluation is pointed out, a certificate was stated. Lords, my learned friend said that if there is a deficient, that will be another proceeding will be there that will be collected, lord. The case was started for realization of deficit stamp duty, extra registration fee, but the executant said Bharati Patra intentionally avoided to pay the proper stamp fees, extra registration fee, and when the show notice issued to the claimant, Srimati Raspireka Mahanti, she also avoided.
There is a procedure for impounding the document. If stamp duty is not paid, you follow those things. What is the criminality in it? I don't understand.
Criminality is brought.
The whole allegation is some documents were registered without paying proper stamp duty. This is your allegation. And this has been done in connivance with the registrar and all. And sanction was sought. Sanction was not granted insofar as registrar is concerned. Because no case, there is no intention, nothing. So sanction is not given. Rest there. And these 2 people are the beneficiary of those documents. If they have given less stamp duty and there is a procedure, it has to be referred to the stamp collector and it will be impounded and penalty has to be given. That consequence is different. Where is the charge sheet for that? Why should you file a charge sheet against them?
But charge sheet is that because the section 125 is there, my lord. The conspiracy aspect, my lord. Lord, I agree, my lord. Lordship, can be with me 2 minutes, my lord. I agree with your lordship, my lord, that so far this not following the circulars, not complying the circulars, I agree, my lord, they are not. But they act in tandem, my lord. What, my lords? My lord, they are the co-conspirators.
Tandem with whom?
My lords.
The registrar.
Who is
the real accused? Registrar has registered the document?
No, my lord, the staffs, my lord. In that circulars, my lord, the staffs has to place that particular circulars, my lord. There is a procedure, my lord.
Registrar doesn't know. Registrar doesn't know.
After that, my lords. And in this case, my lord, in the absence of registrar, lords, you can turn to the page 13 of your lordship. Page 13.
Can you secure conviction in this case, even if they put to trial?
My lords.
Can you secure conviction?
No.
If this is the matter.
I am in a particular mission. How they will wriggle out on this, the factum of conspiracy. My lords, you can turn to page 13, my lords.
13.
It's difficult for them to wriggle out, my lords. Lords, we turn to page 13 of the brief, my lords.
130. Yes.
And my lords, you can say dealing clerk, say Behera, one of the accused, my lords. Then my lords, Ramesh Chandra, second para, second. There, my lords. In the above, it is evident that so and so, my lord, the dealing clerk and registration of the state, law so and so certificate or document enabling. And my lord, in the absence of without ascertain. And now I've got the statements of the in 161 statement, my lord. In the absence of registrar, these clerks, my lord, they did every mischief, my lords. And my lord, they can't say that they are not extending solidarity or the helping hands to these particular 2 persons who are the beneficiary.
Have you proceeded against them departmentally? All these are all dereliction of their duty. They should be departmentally prosecuted.
In part, their dereliction of duty, but charge sheet at least my learned friends already submitted.
You impound the documents.
Yes, my lord. That proceeding is there. He is participating, my lord. Without participating there, my lord. And my lord,
the other consequence, participate, no.
Without they put it in the mutation.
Whether you have impounded the documents.
My lord, he is not coming, my lord. The entire purpose is abruptly, my lords.
He is not coming, therefore he has to face a criminal case.
No, that's not the point. The point is that they are part of the conspiracy. Conspiracy with the staffs of the public servants.
From the record, you show me the conspiracy. From the record, you show me the conspiracy.
Then, my lords, I'll just place the entire thing from the order. Let it go tomorrow. I'll take charge of it.
From the record, you show me the conspiracy. That's all. And where is the order by which the sanction was declined? Where is that order? No, the registrar.
It's not that order, person to.
Get that order also.
I'll
There,
Annex 2, page 16, kind of.
Annexure 2.
Lord, my submission would be on the basis of that once it's set.
No, Annexure 2?
Are they relevant?
2, page 16.
That is the court order.
Yes, court order, because of that only his case was allowed.
No, where is that order declining sanction? There must be reason
that order
for that.
I'll
Where is that
discuss
order?
that one.
Get that order. In that order, everything would be might have written.
Perhaps it will be.
If he goes and everybody has to go.
Not necessarily.
No, it should.
Not necessarily.
It is necessary.
This is my submission only. That's all.
It is necessary corollary. Main person is the
Things have to be claimed, my lords. Someday, all kind of things are going on in that recession. And my lord, these clerks, my lord, they are working in hand in gloves with this particular person. And they
You may be correct, but in the record you have to make out a case.
Yes, I'll play. That is my the onus is on me.
Yes.
Satisfied to your lordship, my lords. Your lordship put it somewhere. I will come back to your lordship with that particular.
After
He's making submission contrary.
No, it's a compilation. It's a compilation only. क्या बात बोल रहे? It's a compilation only.
43 can I see the.
he has taken a promise that whatever he has written, he will argue contrary to it. So that's after for some time submits that he would produce the order by which the sanction to accused number 1.
1 and 2.
Accused official accused, namely registrar and
Sub-registered, head clerk and head clerk is.
no sanction.
Maximum vehicles only sub-registered.
Sub-registrar, sub-registrar has been declined. We'll find it. This is the matter for further argument. Further argument on. Maybe on 27th. 27th. Get that sanction, get that order by which the sanction is declined. Because all these things might have been placed before the sanctioning authority.
But all these persons tented they should not sell with the persons who have been let off, my lords.
Yes.
Well, I wish your lordship put it on first possible.
First, there are a lot of matters. Let it be on 9th then.
In fact, my learned friend is provided with an order to ensure adjournment in the court will already the other bench has.
Then let it be on 9th. 9th September. 9th September. Entry mode to continue.
No entry mode. It's only he has been provided with the opportunity to make a prayer for adjournment.
Now is more of a reason that he should get an entry order.
Yes, I will be ready. Ever ready.
Yes.
Yes.
No case is made out, in fact. Very difficult. Yes.
71.
Sorry? Ready? This is no, this appeal is admitted. Already admitted. Yes. Why for it is listed? It is a order against acquittal, sir. Leave to appeal has been granted. What are the offences, Jesse? Yes. Let us see.
There's no one complainant, another 2 witnesses. Other chance again. Very well proved the order. But the London court has discarded them saying that there is a discrepancy in the statement. So they are not trustworthy.
Show me the judgment. Let us see the judgment.
The paper book.
Yes. Judgment. Yes. Read the judgment. Yes.
Page 20.
Yes, you read it. Only 3 witnesses were examined. Yes, let us see. Which part?
The para 11 of the judgment.
Yes.
At the end, that is in the page 20.
Para 11, you read para 11. The complainant has admitted in his evidence.
And Sanchukta, who is the daughter of the accused number 1.
Uh-huh.
Further, it has been spelled out in the complaint petition that on date 26/8/92, while the complainant and his father were absent from the house, the accused signature partner and his wife took away Sanjukta. Sanjukta carried the gold ornaments with her. Since then, no information was given to the complainant regarding his wife. On 19/9/92, at about 2 p.m., father of the complainant had been to the quarters of the accused person in order to bring back the wife of the complainant. He was misbehaved by the accused person, accused teacher and partner. On the same day, the complainant had been to the quarters of the accused person twice, at 4 p.m. and 7. When the father of the complainant was misbehaved by the accused teacher and partner, and when the complainant was refused to take back his wife twice, I found it difficult to believe that the complainant alone had been to the spot on the date of occurrence. Furthermore, I found it difficult to believe that all the accused persons except the accused Deepak had assaulted the complainant. Prosecution witnesses have evidence that the being assaulted the complainant sent bleeding injury on his thumb, and his wearing shirt became stained with blood. That blood-stained shirt has not been produced in the court. During course of time, it is believed that being assaulted, the complainant sustained bleeding injury. As a result of which the shirt became stained with blood. Then, in the case, he must have received some medical treatment. Moreover, the complainant has stated to have been medically examined in this case. Although no portion that of that flat where the accused persons are residing have been examined. I have already discussed that the evidence below 2 and 3 are full of discrepancy, contradiction, and the same are not trusted.
What is wrong in it? Where is the perversity? You make allegation that you have been attacked and all, and no medical examination, no nothing is there. Let us see PW2. Let us see PW2. PW? Let us see. I know the occurrence took place on 370 in the quarter of accused Sri Chand Patra at Lakshmi Sagar. At that time, I had been to collect my dues. I supplied rice and so on. Narendra Bhola was present with me. Narendra Bhola.
The chief, the very well have stated.
Read it.
I know the parties. The occurrence took place on 29/92 at about 7 a.m. in the quarters of the accused teacher and partner at Lakshmi Sagar. At that time, I had been to collect my dues as I supplied rice to the accused others. Narendra Bola was present with me, that is PW3. I had a commotion which was coming out from the quarters of the accused teacher. Arriving there, I saw the accused Sri Charan was assaulting PW1. Accused Babli Patra being armed with facilities, accused number 5. With the Fasa threatened the assault. PW1, I intervened in the matter. PW went out. PW1 went out. Then after charge, my village situates at a distance of 30 kilometers from the spot. Being informed by PW1, I have come to the court today for giving evidence. 2 years prior to this occurrence, the accused teacher was taking rice from me and Narendra.
Who is injured according to you?
This is PW1.
PW1, let us see PW1, what it says. The occurrence took place on the injured. Informant is also, he is the complainant.
Yes.
I found that the accused and wife are assaulting the complainant. No. He is not the injured. PW1 is not the injured.
PW1 is the complainant, so he is the injured.
Para 2 just see. Occurrence took place on 29 so and so at 6 traffic so and so.
Then
I had been to give rice in the house of
PW2.
No, PW1 40 page 40 paper book. when I went inside their house, I found that the accused Srichand and his wife were assaulting complainant.
In the next page, if you lordship see 42, there is a deposition of witness number 1 from the prosecution. Yes, Lord.
But it's PW1 like
Narendra Vola is the PW3. It is in specific.
42 of the paper.
42. But it's PW1 is written. No, ulta. Okay, yes. Yes, PW1 is PW1. It's wrong.
Para 3.
Page 40 is wrong.
Yes.
Yes. 40 is wrong. Yes.
Para 3.
Para 3, yes.
I have married
to Sanjukta and who is the daughter of accused Srichand.
on the date of occurrence at relevant time, I had been to the quarters of the accused Srichand in order to bring my wife. I knocked at the door. The accused Srichand opened the door and dealt 2 slaps on my face and gave 2 pushes by holding my neck. There was bleeding in my teeth. Then he caught hold of my shirt and told me as that I will take you along with your parents by putting handcuffs. Then he gave me a push to the result which I fell down from the stair. Then accused number 2 is the mother-in-law. The 3 was stick at me and abused her. The broomstick. Then the daughters gave kick, and the son who with a came out with a farsa and threatened of that to kill, which the PW 2 and 3 has seen.
He refused to accept the FIR.
Yes, sir. Because it's a though it's arising out of a matrimonial dispute, but this occurrence has happened. He had been to take his wife from his in-laws, and he was not allowing him. That is the
The accused number 1 is the father-in-law.
is the complaint.
Srichand.
Accused number 1 is the father-in-law. Accused number 2 is the mother-in-law. Then 2 daughters are here.
Father-in-law. Mother-in-law is no. Mother-in-law. And who is Dali Patro?
The daughters of
Huh?
accused first. Daughters.
Daughter, sister-in-law.
Ask the brother.
Where is the perversity in the impure? I don't see it.
Had the report is found not the PW2 and thing untrustworthy. And on that conviction because they have very much proved the occurrence. Only because of minor discrepancy about the timing of arrival, the learned court has discarded their that should not happen. It's a relative as a whole. It shows the crime has.
Okay. Reserve, huh? Okay. Dismiss. Nothing is there. We will try. Okay.
72.
72. Yes. You're for appellant.
Okay.
Yes.
For the appellant, 2 appellants are there.
Yes.
They have been the order of cognizance for fabricating false evidence for the offense under section 193, condition number 193, IPC is being challenged.
Cognizance order.
Cognizance order, but it is an appealable provision as per the CIPC. Section 341. May I refer to section 341?
341. Okay, 340 is 341 applicable. Yes. Yes. Yes.
Right. And I beg to challenge this order of cognizance on primarily 4 points. First one is the merit. The second one is that before the order of cognizance is passed, a notice to show cause.
What have you done? Which document? What have you made?
The facts are that a girl was subjected to sexual assault, and after the registration of the FIR, the girl was produced before these 2 appellants who were doctors serving at Khurda, and the occurrence took place on the particular date, 2nd in the night, 11:30, I think is the time of occurrence and the report was promptly made. And even one of the accused, it is stated that she was subjected to sexual assault by 4 persons and one was also arrested. However, the girl was produced before these 2 appellants doctors on the following day in the daytime on 3rd. And what has happened? They gave a report. They gave the report indicating that they found one bruise on her breast and they found that the hymen was torn. This was the report they gave. And they did not give any opinion. They referred the girl to the Forensic Medicine and Toxicology Department of SCB Medical College for further examination. And the girl was produced before the FMT Department of SCB Medical College and Hospital on the next day. And these 2 doctors were also present, and in their presence the girl was examined. And the FMT expert who examined the victim girl, he gave the report that the injuries found on the victim girl is suggestive of forcible sexual intercourse. And what has happened, the bail application of the accused, one of the accused who was arrested, was rejected, and the said accused filed an application under section 439 CRPC reporting additional sessions judge. And the additional sessions judge, before the additional sessions judge, argument was advanced by the learned counsel for the accused.
Showing the
reports of the 2 doctors are in variance.
What happened to the prosecution then?
That's it.
What happened to the prosecution to the accused?
Prosecution, I do not know. They must be knowing. It's a long back prosecution must have ended. I don't know. I have no knowledge regarding that.
So they say that the document which was relied upon the prosecution,
Yes, it is.
that is the report of.
Lordship, what has happened? If we go to the merits, there are 2 bruises.
Who has taken cognizance on the basis of whose complaint?
On the complaint of the learned additional sessions judge, the STJM has taken cognizance. And the learned additional sessions judge has made the observation while dealing with the bail application. The charge sheet had not been submitted. Trial had not commenced.
No, it can't be like that.
And the law says
See,
that
if some documents were procured, whatever, if it's a part of the charge sheet, that will be tested in the trial, wrong, right, whatever. Where is 340 about it?
Lordship, the law says that it is at the time of judgment
Yes.
of the case.
Yes, my lord.
It can't be
Even in
193, my lord. Sir.
You see first 340. Series 340.
I am reading up.
Wrong, right, whatever. The doctor has given a report.
Yes.
You have made part of the charge sheet. The accused has taken benefit of that at the time of getting bail. Is it 340 for that? How can it be 340? Let's see 340, read it, 340.
When upon an application made into this behalf or otherwise, any court.
It is a case of or otherwise. Okay.
Any court is of opinion that it is explained to the interest of justice that an inquiry should be made into any offence referred to in clause B of subsection 1 of section 195, which appears to have been committed in error in relation to the proceeding in that court, or as the case may be, in respect of document produced or given in evidence in a proceeding in the
document produced or given in evidence in a form of part of charge sheet, whether it's a document given in a proceeding. Simple.
May I bring
Why 340 for that?
344. If at the time of delivery of any judgment or final order, disposing of any judicial process.
Yes.
And there is a judgment of the Honorable Apex Court on this. Criminal Procedure Code, Section 195.
340, the 340 itself, either in the proceeding, bail is not first of all, bail cannot be treated to be a proceeding. Okay. And second is proceeding, it is a document which is given in a proceeding, in evidence in a proceeding. And that can be tested in the trial, whether the right certificate is given or whatever.
But 192 and 93, my lordship, very glance.
That is the procedure. I am not on the procedure, I am the convenience stage. Where are you going? Why should you go to procedure? Allowed. Set aside. Allowed. Allowed. Yes. This is the next point.
The case of forgery and the cognizance is taken before the document is tendered in evidence. The Honorable Apex Court has held that it is not maintainable. Before the document is tendered in evidence, there cannot be.
Yes, this document is not tested in the trial.
Lordship.
It is not even tested in the charge sheet stage.
Exactly the point, Lordship stated.
So therefore, how can you bring 340?
Before the document is tendered in evidence.
Yes.
But 193.
Which paragraph you said?
The
Judgment?
past,
Judgment, which paragraph you are relying?
there, the past placing down, it is there. But no, I will achieve. Online.
Or 12. Yes.
192, my lordship.
That is a procedure, that is the second step.
That part, my lord, that is the documentary evidence. That's why my lordship, 92, 192, my lord. Can I?
And
Yes.
Whoever caused any circumstances to the exist or
Yes.
any book or record or electronic record or make any document or electronic record containing a false statement, intending that such circumstances, false entry or false statement may appear in evidence in a judicial proceeding or in a proceeding taken by a law before a public servant as such or before any arbitrator.
192 you are reading?
92. And that such circumstances, false entry or false statement so appearing in evidence may cause any person who in such proceeding is to be a form of opinion upon the evidence to entertain an erroneous opinion touching any point material to the result of such proceeding is to be fabricated false evidence.
False evidence. So
Well,
here,
these are
this
evidence.
does not come before the charge sheet is filed.
These are evidences.
Obviously, you have to wait till the charge sheet is filed.
Only 392.
How can you say that it will be used as evidence until charge sheet is filed? It is an case of bail.
Yes. Yes, next. 73. Sorry? You have been appointed in Jamaica case. We're not prepared.
Sir, one more page.
98, 98. Okay, Here कौन सी 75 ओके ये तीनटा मैटर खाली ये जोड़िए खाली जोड़िए ये 75 टन 75 and 73 and 74 73 na 73 74 tomorrow
75 item number 75
no
that matter my lord is can I pray one thing my lord your lordship may take it up day after tomorrow at 2 p.m. so that it can be
what is happening because lot of miscellaneous matter comes in between
no, that is true this is also vigilance case my lord this is also arising out of a vigilance case 1 year conviction and the is
supplementary
and I have
let me see how many matters are there
that is always difficulty kindly
and the only reason why it stayed was because there were two connected other appeals of two other accused persons who stand on a different footing altogether, which your lordships have heard to a certain extent. Now, this case has suffered several adjournments. It was 2011 appeal. It's suffered several adjournments on the ground of the Vigilance Council or the counsel for the other accused persons seeking adjournment.
One day I'll keep it for
3 months. That one
what I can do is for your matter and his matter and vigilance matter.
It's fixed for today, my lords. Item 47. Last week, my lords, it fixed the trap matter.
The problem is
that was also the same thing.
4 o'clock.
My lords, especially
What I can do is one day I'll fix it for the vigilance matters. So that I can take up. You are also vigilance matter. Vigilance matter.
Vigilance is mine is vigilance case also.
Otherwise these matters will never come like this. Out of matters.
And your lordship knows in my case, my lord, a widow is my lord, without my lord, she is unable to support her minor children.
One day we will fix only vigilance matter so that the vigilance council will be here. I'll fix up. His matter is already heard. And I remember that.
I think weekly of evidence on that particular day. The only thing is that he was being alleged that he is the attesting witness. And the day that attestation is supposed to have taken place, on that date he had gone for training. In fact, that during that period he was in training.
Yes. So the other co-exist persons are also there. That's the reason.
Are there who have been implicated for that.
I will discuss with the vigilance councils and then I'll fix all the matters one day and finish it up.
In my case, my lord, I have supplied the note of argument as well as a compilation of judgments, my lord.
You file it so that it will be scanned and I get it.
I'm filing right now.
No,
not counter.
Item 12
weekly 12
supplementary
weekly.
They'll get it. They'll get the report. Get the report.
Appellant has already been died or they seটা
Sole appellant.
Yes, sir.
Item 12.
Against acute lords.
See sole appellant or any other?
Sole appellant. ସେଇଟା ଲାଷ୍ଟ ଥର ଦେଖୁଥିଲି କଣ ହେଇଛି କି
ଆଇଟମ 12 ନା
ଅଲଗାର ଆଉ ଜଣଙ୍କର ଆସି ଯାଇଥିଲା ରାଦା ଦାନ
ଏକ ମିନିଟ ହଁ yes
ସେ 97 ରୁ ଡାଏଟ କରି କୀର୍ତ୍ତନ ପଳେଇ
ଚନ୍ଦ୍ର ପଳେଇ
କୃଷ୍ଣ ପଳେଇ ଆଜ୍ଞା
ଓକେ
କିନ୍ତୁ ସେ 97 ରୁ ଡାଏଟ ହେଲା 97
yes sir dispose of kar de
beg pardon lordship